and our focus is to continue with that enforcement strategy. But just to signify, it's not all about enforcement. Education and engineering are really big parts of the road.
Please be seated. Assembly resumes its business.
Raising of matter of privileges.
None.
Government business bills. First readings. The Director's Registration and Licensing Amendment Bill 2019.
The Honorable Minister.
Bill has been read the first time and sent down for second reading.
Yeah, no.
Yeah, okay.
bill has been set down for a first reading. You call the first reading? The bill is set down for a second reading.
The Securities Investment Business Amendment Bill 2019.
The bill has been set down for a second reading.
The Proceeds of Crime Amendment Bill 2019.
The bill has been set down for a second reading.
Second readings. The Directors Registration and Licensing Amendment Bill 2019.
The Honorable the Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill entitled the Directors Registration and Licensing Amendment Bill 2019.
So ordered. Is the Minister speaking there too?
Yes, Mr. Speaker. Mr. Speaker, I rise to present the bill on behalf of the government. It is a bill that seeks to amend the Directors Registration and Licensing Bill 2014 in order to make changes to the definitions of covered entity. Mr. Speaker, when drafting the necessary legislative amendments to the Securities Investment Business Law 2019 revision, which endeavors to subject excluded persons to a more appropriate degree of regulation and supervision by the Cayman Islands Monetary Authority, which I'll be speaking to in more detail during the presentation for a bill to follow, Mr. Speaker. It was noted that a consequential amendment to the Directors' Registration and Licensing Law would be required regarding the defined term covered entity. Mr. Speaker, as currently drafted in the law, the term covered entity relates to a company to which paragraphs 1 and 4 of Schedule 4 of the Securities Investment Business Law apply. The amendments to the Security Investment Business Law, which this House will consider, include a modification to Schedule 4 and as such have caused a consequential amendment to the definition of covered entity in the Directors' Registration and Licensing Law to be required. Mr. Speaker, the bill consists of two clauses. Clause 1 of the bill makes provision for the short title of the legislation and commencement. Clause 2 of the bill amends the definition of covered entity, changing reference from paragraphs 1 and 4 to paragraphs 1 and 2. So, Mr. Speaker, this concludes my presentation on the proposed amendment bill. In closing, I wish to thank the Ministry staff and the Legislative Drafting Department in their efforts in bringing this bill in relation to the wider legislative changes as appropriate, and I therefore commend the Directors' Registration and Licensing Amendment Bill 2019 to this Honourable House for second reading and eventual passage.
Member wish to speak? The member from Bordentown West.
Thank you very much, Mr. Speaker. I rise on behalf of my colleagues and the official opposition to basically lend our support to this consequential amendment as a result of a change that's coming in another bill. So we just rise just to record our support of what the minister is doing.
Does any other member wish to speak? Does any other member wish to speak? Call now on the move of the bill to.
Thank you, Mr. Speaker. Mr. Speaker, I'd like to thank the member from Bordentown West on behalf of the support that he has offered on behalf of the opposition bench for the passage of this bill, and thank all members on this side of the House for tacit support as well.
Question is, the bill entitled, "A Bill for a Law to Amend the Directors' Registration and Licensing Law 2014 to make a minor amendment to the definition of covered entity and for incidental and connected purposes." Bill entitled the Directors' Registration and Licensing Amendment Bill 2019 be given a second reading. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The Directors' Registration and Licensing Amendment Bill 2019 has been given a second reading.
The Securities Investment Business Amendment Bill 2019.
The bill has been duly moved. Does the member wish to speak there too?
Thank you, Mr. Speaker. I beg to move the second reading of a bill shortly entitled the Securities Investment Business Amendment Bill 2019. And with your permission, I would like to speak to the bill at this time. Thank you, Mr. Speaker. Mr. Speaker, I rise to present the bill on behalf of the government. It is a bill that seeks to amend the Securities Investment Business Law 2019 revision, which I will be referring to as CIBL hereafter, in order to introduce a regulatory and supervisory framework applicable to persons currently registered as excluded persons. Mr. Speaker, the amendments to the CIBL law stem from the review conducted by the Cayman Islands Monetary Authority of the entities that are allowed to be excluded from the law's licensing requirements. Those entities are known as excluded persons. The review identified a number of weaknesses and challenges that may pose regulatory and reputational risks to the authority and the islands. Mr. Speaker, the bill seeks to provide for the adjustment of the excluded persons regime and for incidental and connected purposes. Mr. Speaker, in March 2019, the Caribbean Financial Action Task Force, or CFATF, issued its latest assessment of Cayman's anti-money laundering, counter-terrorist financing, and counter-proliferation financing regime, AML, CFT, or CFP for short. As was done during previous assessments of the jurisdiction, the CFATF evaluated technical compliance, which seeks to confirm that the jurisdiction has the necessary legislation in place. However, Mr. Speaker, in accordance with the CFATF's updated methodology, and for the first time, the effectiveness of Cayman's legislation was also, and framework, was also evaluated during this fourth round evaluation. The CFATF report published in March of this year identified gaps in our AML, CFT, and CFP framework regarding availability and accuracy of information, interagency coordination and cooperation, international cooperation, and monitoring and enforcement. These gaps subsequently affected our jurisdiction's ability to satisfactorily demonstrate effectiveness to the standard that they required. As a result, the CFATF issued 63 recommended actions in its fourth mutual evaluation report impacting multiple law enforcement and regulatory agencies, departments, and authorities. The Cayman Islands is now in an enhanced follow-up and a one-year observation period that ends in February 2020. Failure to address the recommended actions within that time frame means risking further FATF-related actions affecting the jurisdiction's reputation and ability to attract and maintain business. So therefore, Mr. Speaker, as a jurisdiction, Cayman is committed to addressing the CFATF's recommended actions. As such, this bill seeks to address the following recommended actions provided by the CFATF regarding the unregulated securities and investment sector, namely the excluded person regime. Mr. Speaker, in immediate outcome, or IO1 of the report, the recommended action number 2, it states the Cayman Islands should initiate a comprehensive analysis and assessment of those sectors subject to limited supervision, for example, the civil excluded persons, as well as legal persons and arrangements, including those associated with securities and investments, as well as wealth management, that can be misused for money laundering or terrorist financing and potentially exploited by individuals situated outside of the jurisdiction. Mr. Speaker, IO3 recommended action 1, the Cayman Islands Monetary Authority should gather more comprehensive information on excluded persons, including the size of client assets, business activities, client base, geographic exposure, etc., and conduct more detailed analysis of information to gain better understanding of the MLTF, or that is money laundering and terrorist financing risks posed by this segment of the security sector, and implement appropriate risk mitigation measures. Mr. Speaker, IO3 recommended action 4 states that SEMA should implement more comprehensive mechanisms to conduct fit and proper assessments of shareholders and beneficial owners of the 55% of excluded persons that are not otherwise subject to SEMA's full supervisory regime. And IO4 recommended action 2, Mr. Speaker, speaks to excluded persons not otherwise licensed by SEMA should implement appropriate AML, CFT policies, procedures, and internal controls, including risk mitigation measures. Mr. Speaker, the excluded persons regime as currently designed in Schedule 4 of the CIBIL allows certain persons that carry on securities investment business to be exempt from licensing. These persons currently include a company that carries on activities only for companies in its group, a person participating in a joint enterprise with the person carrying on securities investment business, the authority, that is SEMA, the stock exchange, and the government, a person carrying on securities investment business only for sophisticated or high net worth persons, a person who is regulated in respect of securities investment business by a recognized overseas regulator, and finally, a person carrying on securities investment business only in the course of acting as a director, partner, liquidator, trustee in bankruptcy, receiver, executor, or administrator, or an estate or beneficiary of a trust. Mr. Speaker, the legislative amendments proposed seek to subject excluded persons to a more appropriate degree of regulation and supervision to rectify deficiencies noted by both SEMA and the CFATF. One key aspect of the legislative amendments proposed relates to Schedule 4. Mr. Speaker, the bill amends Schedule 4 of the CIBIL, and the notion of being an excluded person would no longer exist. Instead, persons would be required to be registered pursuant to the law. The intent of this change is to acknowledge that entities falling in the category of, quote, persons required to be registered under Section 5.4, end quote, would now be required to be registered with SEMA and be subject to regulatory oversight. These persons would be known as registered persons and will include the following persons that currently fall within Schedule 4 of the CIBIL, i.e. these persons are currently considered excluded persons. That is, a company that carries on activities only for companies in its group, a person carrying on securities investment business only for sophisticated or high net worth persons, and a person who is regulated in respect of securities investment business by a recognized overseas regulator. Mr. Speaker, under the current law that is in force, there was no method by which SEMA could effectively enforce compliance with the anti-money laundering regulations by excluded persons. Therefore, Mr. Speaker, this bill brings registered persons in scope of monitoring by SEMA, and therefore registered persons' anti-money laundering obligations would now be demonstratable and subject to oversight. Mr. Speaker, the remaining persons included in the current Schedule 4 of the law in force now have been placed in a new Schedule 2A of the bill under the heading of non-registrable persons. Mr. Speaker, non-registrable persons would now include the following persons: a person participating in a joint enterprise with the person carrying on securities investment business, the authority or SEMA, the stock exchange and the government, and a person carrying on securities investment business only in the course of acting as a director, partner, liquidator, trustee in bankruptcy, receiver, executor, or administrator or of an estate, or a beneficiary of a trust. Mr. Speaker, it is believed that these persons do not hold themselves out as conducting securities investment business for profit, but instead, any securities investment business activities conducted are incidental to their main capacities as outlined in the new Schedule 2A, and as such should not be required to register with SEMA as a registered person. Mr. Speaker, I would like to also highlight that a new category of person introduced in the bill, defined as a single family office or single family offices, has been added to the list of non-registrable persons in the bill. Mr. Speaker, the rationale behind this including these persons in the non-registrable persons list is attached to the distinction between persons managing their own funds and persons managing third-party funds. It is important to note that a single-family offices that manage their own wealth are carved out of financial regulation in other jurisdictions as well, namely the United States, Switzerland, Luxembourg, and Jersey. As such, Mr. Speaker, the Ministry decided that this matter could be dealt with by defining single-family office in the law and including this category of person under the list of non-registrable persons in Schedule 2A, in keeping with the international industry norm. Mr. Speaker, to ensure that single-family offices will be regulated by SEMA for AML, CFT purposes, however, an additional amendment has been prepared in regards to Schedule 6 of the Proceeds of Crime Law and will be brought forward by the Attorney General in his presentation of that bill. Mr. Speaker, the Ministry of Financial Services ensured that industry practitioners were consulted and their feedback and comments were taken into consideration when drafting the bill being presented today. Industry consultation was undertaken through Cayman Finance's Investment Funds Subcommittee, the Alternative Investment Managers Association, AMA, Cayman, and the Forum for Harmful Tax Practices, the FHTP Fund Management Working Group, which the government has established. 4 rounds of industry consultation were conducted over a 10-month period. The first round of consultation lasted a month, beginning the 17th of July 2018 and ending 17th of August 2018. The second round of industry consultation lasted for 2 weeks, beginning on the 29th of October 2018 and ending on the 12th of November 2018. The third round of consultation lasted a week and started on the 12th of February 2019 and ended on the 18th of February 2019, and the final round of industry consultation lasted for 2 days, beginning the 12th of March 2019 and ending on the 14th of March 2019. Mr. Speaker, the Ministry of Financial Services also engaged with and included the Cayman Islands Monetary Authority throughout this process and during each round of consultation. In addition, Mr. Speaker, the Ministry has received a number of comments since the bill was gazetted on April 16, 2019, and as a result, there are a number of committee stage amendments to the bill that will be proposed at that time. Mr. Speaker, to reemphasize, the purpose of separating the entities listed in Schedule 4 of the CIBIL is to consider the risks that are posed by those persons. Those that fall within the category of registered person in the proposed Schedule 4 of the bill are would be required to register with the authority, that is SEMA, and would be subject to enhanced reporting requirements and regulatory supervision given the higher risks they pose to SEMA and the jurisdiction. While it is also clarified that those fall within the category of non-registrable persons remain outside the scope of CIBIL for the reasons that I discussed earlier. Mr. Speaker, in a nutshell, the bill seeks to remedy the recognized shortcomings of CIBIL, namely to deal with the pejorative connotation associated with the term excluded person, to deal with the lack of supervisory powers over excluded persons, to deal with the limited information filed in the annual declaration for excluded persons, to deal with the lack of deregistration requirement where a person ceases to carry on securities investment business in the islands, and the ability to be wound up where the excluded person is found to be in contravention of the law. It deals with a deadline for annual filings, the inconsistency with the deadlines for other entities, that being January of each year. And it deals with the lack of penalties for non-payment of fees, the lack of regulatory powers to correct non-compliance with legislation, the lack of offense for operating without being registered, and it also deals with the inadequate governance requirements, such as no requirement for excluded persons that are companies to appoint at least 2 directors that are natural persons or a corporate director, and the no explicit requirement for natural persons to register as corporate vehicle before conducting securities investment business. And these amendments were felt to be necessary to ensure that the registered person has an effective corporate governance structure in place, which includes accurate and accessible information and accountable management. So, Mr. Speaker, looking specifically at the bill being proposed, the bill is arranged in 21 provisions or clauses. Clause 1 of the bill makes provision for the short title of the legislation and commencement. Clause 2 of the bill amends Section 2 of the principal law to provide definition for words used in the legislation. Clause 3 of the bill seeks to amend Section 4 of the principal law dealing with the categories of persons carrying on securities investment business to include limited liability companies formed under the Limited Liability Companies 2018 revision and the limited liability partnerships formed under the Limited Liability Partnership Law 2017. Clause 4 of the bill inserts sections 4A, 4B, and 4C so that the authority may exercise discretionary powers in relation to an applicant for registration and exercise enforcement powers against a registered person, so that the authority may direct a licensee or registered persons to cease or refrain from performance of specified acts, and that to allow a registered person to be prohibited from acting as a depository. Clause 5 seeks to amend Section 5 of the principal law to make provision for a person to apply for a license or registration. The clause sets out the procedure for registration as a registered person. A person listed in Schedule 4 of the principal law is required to apply for registration. The applicant is obliged to meet a number of requirements, including the applicant's shareholders, directors, and senior officers are fit and proper persons. Additionally, where the registered person ceases to carry on the securities investment business, the person shall, among other things, notify the authority of its intention to deregister and file the requisite information in a manner specified by SEMA. Clause 6 seeks to amend Section 6 of the principal law to include non-registrable persons listed under Schedule 2A as persons who are not required to be licensed in respect of the carrying on of securities investment business under specified laws. Clause 7 of the bill seeks to amend Section 8 of the principal law to provide the shares in a company or interest in a partnership which is a registered person shall not be issued, and where issued shall not be voluntarily disposed of without SEMA being notified of the disposal. Clauses 8 and 9 seek to make consequential amendments to Sections 9 and 10 of the principal law regarding the use of the words connoting securities investment business used within the name of the licensees and the requirement to segregate clients' funds and property, respectively, making these provisions applicable to registered persons. Clause 10 of the bill amends Section 12 of the law to replace a reference to a financial secretary to a minister with responsibility for financial services. Clause 11 seeks to amend Section 15 of the principal law to set out the requirements regarding directors in the case of a registered person. The registered persons shall notify SEMA within 21 days of any alteration made in respect of senior officers. Clause 12 seeks to amend Section 16 of the principal law to make the provision applicable to registered persons, specifically the receipt of regular returns, on-site inspections, auditor's reports, when the authority considers it necessary. Clause 13 seeks to amend Section 17 of the principal law to enhance the enforcement powers of the authority. The clause seeks to amend the principal law to empower the authority to carry out a range of actions where it has reasonable grounds to believe that a licensee or a registered person is, among other things, unable to meet its obligations as they fall due, carrying on business fraudulently, or has contravened any provision of the law. SEMA, in response, may, among other things, Mr. Speaker, revoke the license or cancel the registration, impose conditions on the license or registration, or apply to the court for an order to protect the interests of clients. Clause 14 and 15 seek to amend Sections 18 and 19 of the law regarding injunctions, restitution, and disgorgement orders, and the duty of the auditor, respectively, making these provisions applicable to registered persons. Clause 16 seeks to amend Section 21 to, among other things, empower SEMA to apply to the court for an order for a registered person in contravention of Section 5.4, that is, provisions relating to the registration as a registered person, to be wound up by the court even where voluntary winding up proceedings have commenced. Clause 17 seeks to amend Section 22.4 so that the provisions which allow a licensee to apply to the court to extend the time within which a notice of appeal against the decision of the authority may be served also applies to a registered person. Clause 18 seeks to amend Section 23 of the law to adjust the reference to Section 17.2.1 and 8 to Section 17.2AA and Section 17.2AH as a result of the amendments to Section 17 of the principal law. Clause 19 seeks to amend Schedule 2 to provide for non-registrable persons. Any person listed as a non-registrable person that is conducting the activities specified shall not be considered to be conducting securities investment business for the purpose of this law. Clause 20 seeks to amend the principal law to make provisions of the new category of persons known as registered persons. The clause repeals Schedule 4 of the principal law and replaces it with the schedule that sets out the different categories of registered persons. And finally, Mr. Speaker, Clause 21 provides for persons who are registered with the authority pursuant to paragraphs 1, 4, and 5 of the repealed Section 4 who wish to continue the securities investment business as registered persons on the commencement of this law. Mr. Speaker, this concludes my presentation of the proposed bill. And as I indicated earlier, there are committee stage amendments to be made to the bill to clarify certain clauses, to make various enhancements, and to incorporate the constructive feedback received during the public consultation when the bill was gazetted, and all of which will be presented at that time during committee stage. I would like to thank, Mr. Speaker, the staff of the Ministry of Financial Services, SEMA, the Legislative Drafting Department, and all who participated during the public and sector-targeted consultation for their efforts in the preparation and informing this bill. And I therefore commend this bill to this Honourable House for a second reading and eventual passage.
Does any other member wish to speak? The member for Bordentown West.
Thank you, Mr. Speaker. No, man, just the rest on. Thank you. Thank you, Mr. Speaker. Mr. Speaker, I rise to make my contribution to this bill that is before the Legislative Assembly at this time on behalf of my colleagues in the official opposition. Off the bat, Mr. Speaker, I want to say that we support the changes that the minister is bringing, but our support, we just want to highlight the reasons for our support. First, Mr. Speaker, we have to accept that we are living in a changing world, and the times in which we can have people inside our jurisdiction doing business and we don't have a better understanding of what business they're doing can no longer continue. The minister in her remarks spoke about the excluded persons that were being looked at right now. And just for the members in this house, just to put things in context, if you were to visit the SEMA website and look under the regulated sectors and look under the security section, you will see that between 2011 and 2019, the number of licensees increased from 29 to 36. But more importantly, Mr. Speaker, the number of excluded persons increased from 2,156 to 2,885, an increase of 25%. In considering that in this day and age, the importance that this jurisdiction has with regards to anti-money laundering and countering terrorist financing, this is a responsibility that we in the Cayman Islands have to take very seriously. I have always asked the question, what would have happened to our financial industry if one terrorist on one of those 9/11 flights were ever deemed or considered to receive funds from a bank account in the Cayman Islands? What would the U.S. have done? And at that time when they were looking for revenge, I would hate to have think what would have happened to us and our financial industry. The second reason, Mr. Speaker, why why we in opposition are actually supporting this bill is for the importance that the financial industry plays within our local economy. Now, one of the things that the industry have not done a good job at, Mr. Speaker, and you can pick it up from when you speak to many people in the Cayman Islands, that I don't think many people truly realize or appreciate the importance that the financial industry plays. Now, just to give you an idea, Mr. Speaker, it is well known that our financial services industry drives around 55% of our GDP at least. But what is not well known, Mr. Speaker, is the fact that less than 10% right now of our working population is actually, within our employment industry, is actually employed in financial services. Just to put, to kind of give you an idea, Mr. Speaker, back in 2010, we had 3,638 people employed in the financial service industry out of a total population of 34,983 within the employment industry, which represented 10.4%. At the end of 2017, Mr. Speaker, as per the Compendium of Statistics, we have 3,356 people employed in financial services out of a total employment industry of 40,856, representing 8.2%. In short, Mr. Speaker, when you do understand how the market operates, you will recognize that what we have to do to defend the financial services industry is something that we can't take lightly, and is one of the things that we can't play politics with. To kind of put that in context, we had some concerns with regards to the amendments, and I can say to this honorable House and the general public that I did reach out to the minister, and the concerns that we raised are actually the concerns that she's also already indicated that will be addressed in the committee stages in terms of some amendments that they will be making. But the point I want to make in all of this, Mr. Speaker, is that when the two numbers that I gave you a while ago, between 2010 and 2017, is that during that same period of time, the total employment industry grew by 5,873 persons, but yet, at that time, the total amount of people employed in financial services actually decreased by 282. So in essence, Mr. Speaker, our dependency on the financial service industry continues to grow. Now, in economics, Mr. Speaker, they have a term that they use called a dependency ratio. And to kind of put it down, it's as simple as layman's term as we can. If you have 10 people living in a house and only one person is working, it means then that 9 people are dependent on that one person. So in other words, you have a dependency ratio of roughly 90% because that's how many people are dependent on that one person to work. And when you look at the role of the financial services industry in the Cayman Islands, the small amount of people that it employs, but yet the vast impact it has on our local economy goes to highlight its importance. One example, Mr. Speaker, that I think can probably bring my point home much easier is during the 2008 financial crisis. There's this story where a German tourist decided to go visit Greece. And during his visit, he decided, you know what? I'm going to go to the countryside and I'm going to check it out. And while he was in the countryside, he saw a nice little villa. And he says, you know, rather than stay in the city, I think it'd be best for me to probably stay in the villas. Now, one of the things I should mention is that his wife was expected to come and visit the next 2 days. So he said, you know what? He went into the owner of the villa and he says, listen, I'm booked to stay elsewhere, but I'm really thinking about staying here. My wife is coming and our anniversary is coming up, and I think it probably would be great if maybe I stay there. He says, well, I only have one room left. I'm not sure if the person is going to show up, but why don't you leave a deposit, walk around the place, and see if you enjoy the place, if you like it. So he left a €100 deposit and decided to walk around the town. As he was walking around the town, Mr. Speaker, the owner of the villa decided to take the $100, run to the milkman and says, listen, you deliver a lot of milk for me the other day. I couldn't pay you. Here's $100 that I owe you. So he paid him the $100. The milkman at that time decided, you know what? I just realized when my truck broke down and the mechanic fixed my truck for me, I owed him some money. So let me run and pay him now. So he took the $100 and he ran and paid the mechanic. The mechanic decided, you know what? The other day when I had a conference with my employees and I needed someone to organize a little conference room for me and everything else, I took that on credit. I didn't pay the person. Let me pay the person now. So he paid the conference organizer $100. And then the conference organizer said, well, the other day when I couldn't find some place to have a conference, I bought a little room in a villa. I owed a guy $100. Let me run and pay him. And he went and gave the villa owner the $100. Shortly thereafter, the German tourist came back in and said, you know what? My wife decided she doesn't want to stay here. Want to cancel the trip. I need to go back to Germany. I'll take my money back. And the villa owner handed him the $100 and he left. I saw that to say, Mr. Speaker, in that example, everyone got paid. But where's the money? The money is gone right back to Germany. And that is, in essence, Mr. Speaker, the important role that our financial services play, in that it is the driver of our local economy. Construction and all the development that comes is still a supply industry. It goes by demand. Someone has to demand a house being built. Someone has to demand something being done. And where the money originally comes into this country is either through financial services or tourism. Those are the driver of our local economy. And I say that to say, Mr. Speaker, in that when I was speaking to some members of industry, they were basically complaining once again about, the changes, the this and that that's coming. And it is, for some of these people who have been in this business for a long time and have seen the financial industry change, I accept that sometimes change is difficult for them to accept. But we also have to accept now, in this day and age, in this world that we're living in, the way in which we did business in the old days cannot continue. And the minister in her remark had referred to reputational risk and regulatory risk. I mean, reputational risk itself, Mr. Speaker, is self-explanatory, in that when we do get the bad headlines and the Cayman Islands is featured, then many of us, when we watch Hollywood and see the things that they speak about the Cayman Islands, we don't like it. But also regulatory risk, Mr. Speaker, is literally the risk of what can happen within a market, a business sector, or even a country when the laws and regulations change. You could be doing something today, a law changes and it affects your business, and it does have a financial impact. I say all of that to say, Mr. Speaker, in that in this day and age, we cannot no longer accept being a part of a global community, operating on a global standards, that we can continue doing business as usual. And to have 2,885 persons at the end of March, we're doing business in the Cayman Islands and not having an idea where what the anti-money rules are, or what their anti-money laundering behavior, or what their counter-terrorism financing behavior is completely unacceptable. And as such, I encourage the government not just to look at this sector, but look at any other sectors where we do have the risk of having either reputational damage to the Cayman Islands, of people doing business here, and we're not fully understanding what it is that they're doing. With that, I just want to thank the Minister, one, for taking my call and addressing the concerns that I had in this regard, and two, to ask members within the financial services industry to understand the importance that this industry plays in the Cayman Islands. And while change is never easy to accept, it is still nonetheless one of the things that we have to deal with if we want to remain a player on the global stage. We have to operate to some extent by global rules. With that, Mr. Speaker, I will thank the Minister and our government for these changes, and we look forward to working with them on any other changes. As we have said before, there are some things that we cannot play politics with, and the financial service industry is too fragile and too easily moved for us to be playing politics with. We must maintain an atmosphere where people know that the Cayman Islands is a place that's good to do business, and more importantly, that the market is certain of what it is that we're doing, and we try not to have any level of uncertainty or any other major issues within this market. With that, I conclude my contributions. Thank you.
The Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I rise to give my support to the bill being debated, and just to lend my voice to the basis or the background outlined by the Honorable Minister for Financial Services as to the reason for these legislative amendments. Mr. Speaker, we are in difficult times, to say the least, but not unfamiliar territory. There's a history as it relates to the Cayman Islands with fighting these initiatives and constantly having to remind the world that our framework as it relates to money laundering, tax compliance, and all the things are as good as, and in some cases, much better than some that exist elsewhere. But, Mr. Speaker, for some reason, we have not been able to get the benefit of the doubt when it comes on to that. And there are some countries, some delegates, some multilateral agencies who are simply just not interested in being confused by the facts, really. And so we find ourselves going through the fourth round of mutual evaluation and having to make adjustments to our legislation as well as our administrative and other framework in order to satisfy these requirements. Mr. Speaker, we have expressed to the world our continuing commitment to ensuring that the financial services industry in the Cayman Islands does not provide any safe harbor for those who are involved or interested in any sort of illicit activity. But it is difficult to keep up with these international standards, if for no other reason than the fact that, Mr. Speaker, the rules are constantly changing. They're changing midstream. The goalposts are always shifting. And when we think we're there, in the middle of the game, the rules are adjusted, and so we have to recalibrate. And Mr. Speaker, I mean that, literally mean that. In the fourth round, the rules are changing as we speak. We were just in Trinidad last week, where reports were being discussed, and a country like Jamaica, who had gone through the fourth round is in the follow process, found themselves having to readjust again because the rules as it relates to a certain monetary threshold was literally changed overnight. And so Jamaica will have to, among other countries, will have to adjust to the new requirements. And that has been the ongoing story. Mr. Speaker, as it relates to the issue of excluded persons, whatever that means, I'm in full support of the initiatives being pursued by the Honorable Minister on behalf of the government. It is one of those pejorative expressions that have been employed in our legislation, and I dare say, certainly as was evident during the fourth round mutual evaluation, was one that was used to our detriment. During the discussion of the report in Barbados in November last year, there was a constant refrain, Mr. Speaker, of the risk posed by the Cayman Islands. And there's an expression that is employed in the fourth round mutual evaluation about risk and context. And so a number of things were thrown at us. One was that there's a $1.15 trillion money supply moving through the Cayman Islands. And the other is that, according to some of those who oppose the Cayman Islands evaluation exercise, there was also the issue of the excluded persons. And of course, there was also mention about the fact that there was no discernible supervisory authority for lawyers. And the combined effect of those, Mr. Speaker, along with other things, means that in the risk and context framework or concept, the Cayman Islands was a very high-risk jurisdiction. And that sort of sets us apart from some of the other countries who are involved in financial services business. But for some reason, we seem to have taken on a different sort of attraction as it comes on to, as it relates to risk. So, truth be told, Mr. Speaker, when you look at the excluded persons regime, the honourable member from Buntown West spoke about 2,800 and odd 85 persons, such entities. The truth is, Mr. Speaker, when you really break it down and put it in perspective, 45% of those who are involved in the securities sector are already subject to some sort of a licensing regime. And that would leave approximately 55%. And the question is, how do you account for those other 55%, Mr. Speaker? The truth is that out of that 55%, the majority of those are also attached to some sort of a fund, some sort of a regulated fund, and so would be subject to some sort of a regulatory oversight. Whether it's adequate or not is another issue. but they will be subject to some sort of a regulatory oversight. And the actual figure, and I'm not going to be specific about that, but anywhere between 10 and 12% of that 55% that are really, could be said, Mr. Speaker, to be probably not subject to any sort of a regulatory oversight at all. Something like about 11%, give or take, that are not subject to any sort of a regulatory oversight. So in the grand context of things, a small percentage of those who are involved in this security sector who are not, or who can be said, or may be said to not be subject to any sort of a regulatory oversight. Well, Mr. Speaker, that's not how it is spun. The way it is dealt with, it has been magnified to give the impression that a significant amount of those who are involved in the security sector in the Cayman Islands are not subject to any kind of regulatory oversight at all. They are some sort of a rogue, and nobody knows what they're doing, which could not be further from the truth. And so the effort being pursued by the minister and by the government is really to ensure that 11 or so percent of those who are involved in the security sector are covered by some sort of a regulatory framework, thus removing, as she said, that sort of pejorative nomenclature about excluded persons, and in my view, bringing them into the fold and using the more acceptable term of registered entities and so. But we suffer from this sort of a magnified sort of representation, for want of a better word, about this particular sector of persons who are involved in the security sector. And it is very difficult to convince our detractors that it is not 55% of a vast amount of people, or a vast amount of entities that are not, in fact, regulated at all. So the whole thing is sort of, give the entirely wrong impression. Same thing with our lawyers. It is true that there's lawyers who are not adequately covered for AML purposes. But a significant portion of our lawyers, and those certainly involved in the fiduciary business, money services business, financial services business, some of them are subject to group consolidated AML supervision. Others because of the type of business that they are involved with, trust and company services business and other such regulated businesses. They are regulated by CIMA in respect of those activities. And so there's some degree of regulation. But again, it is not, even though we try to explain that to those who are involved in assessing our framework, they prefer not to see it that way because it fits the narrative and the perception of the Cayman, that they have of the Cayman Islands, if they can say that lawyers are not regulated and the security sector is not regulated. And that is the sort of difficulty we have. We have been fighting this sort of a perception for decades, but we can't seem to convince our detractors, Mr. Speaker, that we have some sort of a regulation, or we apply and abide by international standards. So we simply just have to continue to persevere. The legislations are being amended to deal with not just technical compliance, but in this case to ensure that you have the necessary legislative framework that would then facilitate the administrative framework that would provide the necessary regulatory oversight that the recommended actions in the report suggested. So, Mr. Speaker, you more than anyone else would be familiar with what we are doing here. It has been decades of constant struggle to put these things in place, and each time we think we are there, the rules change, and we are required to comply. But comply we will. That is our mandate, because we are confident in what we're doing, and we are always willing to demonstrate to the world that what we are trying to do is to ensure that the books of business that operate in, from, and through the Cayman Islands are quite legitimate. And so, Mr. Speaker, with those few words, I certainly want to join the Minister and the Honourable Member who spoke and commend this bill to this Honourable House. I thank you.
Does any other member wish to speak? Does any other member wish to speak? Calling up on the Minister to move her right of reply.
Thank you, Mr. Speaker. And firstly, I'd like to thank the member from Bordentown West for the support that he offered on behalf of the official opposition to the bill presented today. And also, Mr. Speaker, want to thank the member personally as being the spokesperson for this area, obviously from the opposition bench, as it relates to financial services matters. I want to, as I did privately, also thank him publicly on the mic for what I find to be the very mature approach that he has certainly demonstrated when it comes to debating issues related to the financial services industry, the bills that have been brought to this House since we have convened as a legislative assembly, and to say that, you know, I certainly welcome the dialogue and discourse that we need to have whenever the opposition has any questions or concerns. I will continue to make myself available to having those discussions, because I believe it's important for the entire country to understand and appreciate how important this entire legislative assembly views the financial services industry, and the fact that one of the key selling points of the jurisdiction as a whole is a stable government and stable political climate. And certainly that, amongst the other accolades that can be said for the country, is a very important factor when business and business people and global commerce, when they consider a place, the jurisdiction to do business and to conduct business, we as a country want to continue to be seen as the jurisdiction of choice to facilitate sound international financial business, and continuing to have a government that understands the importance of this industry, supports it, and does so in a mature fashion that allows the confidence in the country to continue, I think is a very important characteristic of the Cayman Islands. So I want to thank the opposition for as I said, the approach that they have taken thus far in dealing with these matters. I think certainly we on the government bench, and to kind of paraphrase what was said earlier, is exactly what I've said actually most recently on the radio when I was accompanied the member from Prospect when we were doing the preamble to what is to come today at the opening of the House, when we talked about the fact that, you know, we operate very successfully in the global financial services space. But if we continue and want to continue to operate on the global stage, we will have to play by the global rules, and that certainly is a paraphrase of what the member from Bontown West said in his contribution. So again, that is a ringing endorsement that as a country, as a government, we are singing from the same hymn book in that regard. Mr. Speaker, I'd also like to thank the Attorney General for his contribution to this particular bill, and given certainly the longevity of his personal experience in dealing on behalf of the government with these issues, but also the most recent participation at the CFATF plenaries where the issues of the Cayman Islands review were discussed. And of course, he did give and remind the country of what has been dubbed the risk and context of the Cayman Islands, and the prism in which, that is the lens in which through the Cayman Islands is viewed and therefore assessed by the global assessors, and how the challenges for us as a jurisdiction is, yes, in some ways technical, legislative, operational, but also in many ways it is the subjective elements that as a country we continue to be subjected to and continue to have to overcome. And again, but as the Attorney General so aptly put, we have been doing this for decades, and we will simply persevere and deal with the challenges, deal with the expectations, deal with the requirements and recommendations that come our way in terms of strengthening our regime, because, Mr. Speaker, this is an area, as the Attorney General highlighted in his contribution, that continues to evolve even mid-assessment. And so just where we think we might have achieved, the goalpost continues to move. It is what it is. I know the industry is feeling, as I said on the radio earlier this week, the symptoms of the assessment fatigue syndrome. But until, again, going back to the fact that if we want to continue to be dominant players on the global stage, we will continue to have to be subjected to those global assessments. And Mr. Speaker, I am firmly of the view that, as we have done with decades before, and we will likely have to do in decades to come, we will overcome, we will persevere, and we will succeed, and we will continue to be the jurisdiction of choice for sound, regulated, appropriately regulated, and commercially sensible and sensitive legislative and operational framework. So with that, Mr. Speaker, I just want to thank the members that actually participated in this debate, and also thank all other members for their tacit support of this bill.
Question is that a bill shortly entitled the Securities Investment Business Amendment Bill 2019 be given a second reading. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The Securities Investment Business Amendment Bill 2019 has been given its second reading.
The Proceeds of Crime Amendment Bill 2019.
The Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill, the title of which is Proceeds of Crime Amendment Bill 2019, a bill for a law to amend the Proceeds of Crime Law 2019 revision to provide for the inclusion of the Anti-Corruption Commission in the Anti-Money Laundering Steering Group, to provide for the inclusion of virtual service providers in the law to address other deficiencies in the compliance framework and for incidental and connected purposes.
The bill has been duly moved. Is the Attorney General speaking thereto?
Thank you, Mr. Speaker. Yes, I do. Thanks.
Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, just to say that as the Honorable Minister of Financial Services outlined when she moved the Securities and Investment Amendment Bill, the background to these amendments are similar. And the amendments are occasioned by the recommendations that flow from the fourth round mutual evaluation exercise through which the Cayman Islands is, Cayman Islands as a jurisdiction is currently undergoing. Mr. Speaker, I would like to apologize straight up for the number of committee stage amendments that will be dealt with as part of this bill. The fact is, Mr. Speaker, that the bill was gazetted by way of supplement number 1, Gazette number 1, published on the 12th of March 2019, as the intention was to deal with the bill in the earlier session of this Assembly. Mr. Speaker, it was not dealt with then. There are other matters that came to our attention subsequent to, and as a result, the bill was deferred, and the other issues we seek to address by way of committee stage amendments, and hence, Mr. Speaker, a number of committee stage amendments will be dealt with as part of the reading of this bill when it gets to committee. But, Mr. Speaker, the bill itself, as it is currently before the House, deals with a number of amendments to the proceeds of crime law, as I said, which all of which are occasioned by the current exercise through which the Cayman Islands is undertaken. So, Clause 2, Mr. Speaker, deals with definitions, and it provides a definition of virtual assets, which the FATF, in its latest revision to its standards, requires to be supervised for AML CFT purposes. And Mr. Speaker, I mentioned in my earlier contribution about the rules changing in midstream and the goalpost shifted. Well, when we did our on-site inspection and when our technical compliance documents were submitted as part of this fourth round mutual evaluation, virtual assets was not yet in scope as far as the FATF methodology is concerned. But as we go through the process, it has now been brought into scope and is required to be dealt with by the FATF. So it's one of those changes that we face in midstream and which we are required to take on board. So, Mr. Speaker, there's a definition of virtual asset in this bill. The clause provides, Mr. Speaker, that virtual asset means a digital representation of value that can be digitally traded or transferred and can be used for payment or investment purposes. The amendments, Mr. Speaker, provide that activities such as transferring virtual assets and providing financial services relating to the sale of virtual assets would be relevant financial business and therefore subject to the anti-money laundering regulations. An example of that, Mr. Speaker, is we heard about, example of virtual asset would be cryptocurrencies such as Bitcoin. So those are now, Mr. Speaker, to be brought into scope for AML purposes. Mr. Speaker, there is a committee stage amendment dealing with property investment, but I'm not supposed to speak on that until we get to committee, but just to signal that it will be one of those committee stage amendments to be looked at. Mr. Speaker, Clause 3 of the bill provides for amendments to Section 4 of the principal law that would include in the duties of the Financial Reporting Authority the receipt of disclosures required by law, which may include cash transaction reports, wire transfer reports, and threshold-based declarations. Those are now matters that would fall certainly under the purview of the Financial Reporting Authority as become relevant, Mr. Speaker. Mr. Speaker, Clause 4 relates to the amendment of Section 5 of the Principal Law to, among other things, include the fact that the chairman of the Anti-Corruption Commission will now become a member of the Anti-Money Laundering Steering Group. Also, a representative of the Anti-Corruption Commission will now sit as a member of a committee established by the steering group under Section 5.3a in order to see or deal with the implementation of its policies. And that is, Mr. Speaker, that group that we call the Interagency Coordination Committee, or the IACC for short. So a member of the Anti-Corruption Commission will now sit on that body as well. These amendments seek, Mr. Speaker, to satisfy the requirement that the relevant policymakers, the relevant enforcement authorities, and the relevant competent authorities cooperate and coordinate their actions relating to anti-money laundering and combating terrorist financing. The clause, Mr. Speaker, also seeks to satisfy the requirement for compatibility of the anti-money laundering and combating terrorist financing requirements with the laws regarding data protection and privacy. And so the amendment at Clause 4B and E seeks to address these requirements, Mr. Speaker. Mr. Speaker, Clause 6, among other things, seeks to amend Section 201 of the Procedures of Criminal Conduct Law, Procedures of Crime Law, to make it clear that the islands may impose countermeasures that are proportionate to the risk posed by a jurisdiction designated as one which has serious deficiencies in the compliance with recognized international standards for combating money laundering and terrorist financing. It provides that such countermeasures may be imposed in response to recommendation by the FATF or the Anti-Money Laundering Steering Group. Translation, Mr. Speaker, if another country gets a bad FATF report and the FATF blacklist them, and they insist that other countries take countermeasures against them, then Cayman Islands would be able to do so pursuant to this amendment. So we would put them on a list and treat them as a country of high risk, given that we operate a risk-based money laundering framework. Mr. Speaker, Clause 7 seeks to amend Schedule 6 of the Procedures of Crime Law to adjust paragraph 17 of Schedule 6 to ensure that the provision meets with more stringent standard required by the FATF. The provision, as it pertains to dealers in precious metals or precious stones, define relevant financial business as an activity that engages in cash transactions of $15,000. Accordingly, Mr. Speaker, the amendment clarifies that $15,000 cash transaction is for the equivalent of 15,000 United States dollars, not Cayman dollars. So that's a minor adjustment or clarification that we need to make. Clause 7, Mr. Speaker, also seeks to include within the definition of relevant financial business the organization of contributions for the creation, operation, or management of companies by, among other professionals, legal and accounting professionals in the course of business. This amendment also seeks, Mr. Speaker, to address a technical compliance deficiency and identified in the fourth round of the mutual evaluation report. Mr. Speaker, as the FATF has moved to ensure the supervision of virtual asset services I mentioned earlier, this clause 7, also seeks to amend the principal law to include the provision of virtual asset services as an activity falling within the definition of a relevant financial business. The result of this amendment, Mr. Speaker, will be that anyone conducting virtual asset services in or from within the Cayman Islands will be subject to the obligations under the anti-money laundering regulations. I mentioned about Bitcoin and cryptocurrencies and so on. Finally, Mr. Speaker, Clause 7, there will be a committee stage amendment to this clause, but it will deal with the issue of property investment where this is being done without the use of a real estate agent and so. And Mr. Speaker, in short, that's the extent of the amendments proposed in this bill, and I certainly intend to deal with the committee stage amendment when we get to those. But in the meanwhile, I would commend these proposed amendments to honorable members of this House and to seek their support. Thank you.
Does any other member wish to speak? The member for Newlands.
Thank you, Mr. Speaker. I feel a bit disappointed. Some members were expecting the member from Bordentown West to respond, but as the leader of the opposition said, we share the responsibilities. But I wanted to rise, Mr. Speaker, on behalf of the opposition to obviously give our support for this bill, the Proceeds of Crime Amendment Bill 2019. And it's funny, Mr. Speaker, because as we came in this morning, we were presented with a slew of amendments, proposed amendments. So it probably makes little sense to stand here and debate the technicalities of this bill, because I'm sure a lot is going to change when we go through those amendments. But not only do I want to support the Honorable Attorney General in bringing this bill, but I wanted to make some comments as well, some thoughts that came to mind as we went through this bill. And hopefully they'll be taken in a constructive manner. Not that I'm criticizing what is being done, but just some observations. Mr. Speaker, clearly this bill is bringing the law in compliance with the mutual evaluation report of the Cayman Islands. And what concerns me in going through, and I've been here long enough to see the iterations and the changes and the amendments that are coming piecemeal over time. And I did hear the Honorable Minister for Financial Services talk about this fatigue that they suffer from because of having to constantly comply and deal with requirements to enhance our regime in the light of what other jurisdictions think and other bodies and so on, regulatory bodies. And I understand why we have to do that. We obviously have to stay ahead of the game. We have to make sure we keep our financial services on par with the rest of the world. In our case, I think, Mr. Speaker, we have to be ahead of the rest of the world based on what I've seen aimed at us. But we are, I think, doing a good job of making sure that our financial services are protected. But what I think would be useful, Mr. Speaker, is if at some point, because it is hard enough for legislators to sit here and go through these amendments to these bills and keep track of what it is that we're actually changing, how far we've advanced our legislation, and just to get a sort of a pinpoint of where we are in terms of complying with these recommendations and reports. I think it would be useful so that we could actually see the progress. And so, you know, that's something else that we can turn around and use as a PR boost to say that, you know, we are much further down the road than many other jurisdictions. I know we are, but does the rest of the world know that? Mr. Speaker, what concerns me a lot is in reading the actual report, the mutual evaluation report of the Cayman Islands, is some of the statements contained within that report. And again, while I understand that these things are almost mandatory, Mr. Speaker, we have to comply. We have to address deficiencies when they're pointed out. But in looking at some of the key findings, what I noticed was some statements in there relating to the number of successful convictions or lack thereof, rather than how robust our regime is, that we don't have that many incidents or we don't have the need to pursue prosecutions because we don't have people operating in that manner in our jurisdiction or through our financial services. So these reports seem to use the rate of prosecution and the volume of prosecutions as a benchmark for how well your jurisdiction is doing, and if you're not actively prosecuting a lot of criminals and terrorist financiers and money launderers, then clearly, in their view, your regime isn't protected well enough, and I guess they're suggesting that things are slipping through and we're not detecting them. I think what has to happen, Mr. Speaker, is that we start to challenge these reports, not become defiant, but we have to challenge some of these statements and contained in these reports, because it's worrying that we are being painted in this picture and with this broad brush that we are letting things slip through. Another statement that I saw in the report, Mr. Speaker, is that our jurisdiction lacks the sophistication to conduct complex and large financial investigations. Now, again, the proof of that they provide is the fact that we haven't prosecuted very many people. But you could turn that argument around and say, well, we're not prosecuting them because they're not there. They're making the presumption that they are. And they're making the presumption that we're not sophisticated enough to detect and deal with illegal transactions and whatever may be occurring. So I think that there's a lesson to be learned there. While we can't, Mr. Speaker, launch a PR campaign against every negative report and statement in a report, what I think we can do is start to boast and brag a little bit more about how how well we're doing in protecting our financial services. What I would like to see them do, Mr. Speaker, is turn their attention to other jurisdictions that point the finger at us. It's no secret that United Kingdom doesn't get too much criticism when it comes to their financial services. And it is a bit unfair, quite a bit unfair. But, I understand that we must soldier on, we must comply, we must do what we have to do to protect the jurisdiction's reputation. Mr. Speaker, in listening to the Honorable Attorney General in presenting the bill, I think one of the first things he said is that he was going to have to present a number of amendments, which we will have to deal with at committee stage. And that shows you just how quickly these changes come about and these requirements come about. And I must commend his office and the Minister for Financial Services in being able to respond quickly to these threats and these impositions on us, because they are responding quickly and doing what they're supposed to do. But there are so many amendments, and this goes back to what I said previously about kind of keeping track of where we are. There's so many amendments coming now, just a few months down the road, that it's almost as if we're going to have to debate a second bill. And not blaming the Honorable Attorney General, but that is what's happening. It is so fast-paced. Mr. Speaker, the Attorney General also talked about the shifting goalpost. And I don't think I need to spend much time discussing that. We're all aware of what happens. The goalpost gets shifted every time we kick the ball. But the advent of virtual assets now, I think, is critical. I've been following the cryptocurrency argument for quite some time, and I've had some discussions with regard to how do you actually regulate cryptocurrencies, because that is going to be another challenge that we have to face very soon, because the popularity is growing, the demand is growing, and jurisdictions like the Cayman Islands are prime, to offer services within that area. But it's going to be hard to regulate. What I would suggest is that maybe in being proactive, we start looking at drafting legislation that deals primarily with cryptocurrencies, because I think it's a large enough area that it would justify having dedicated legislation to deal with the regulation of cryptocurrencies. Again, just a suggestion in being proactive. But it's a new challenge, and as I heard the Minister say earlier in the previous bill, and the Honorable Attorney General said, we're prepared to deal with these challenges. So, Mr. Speaker, I wanted to just make those few observations and suggestions. Again, we will look forward to the amendments when they come at committee stage. But on behalf of the opposition, we clearly offer our support for this bill and look forward to further discussions at committee. Thank you.
Does any other member wish to speak? The Honourable Minister of Financial Services.
Yes, Mr. Speaker, just to obviously very briefly lend my support to this bill that the Honourable Attorney General has presented on behalf of the government, but to deal with a specific and discrete, comment that was made by the member from Newlands, and that's to do with the, the request to consider, for the government to consider legislation specifically dealing with virtual assets, and to say that, watch this space, we're already moving in that direction. And I know that the ministry has been liaising with the legislative drafting department and working through what those instructions should be. And we've had a number of consultations with SEMA, as well as a working group in industry as well, to kind of help inform from both the regulatory as well as the commercial side how the framework should be. But certainly the Attorney General, I'm sure in his wrap-up, can speak more to that effort as he sees fit. But just to let the member and the listening public know that we are also moving in that direction and hope to bring something to this Honourable House in due course.
Member wish to speak? Does any other member wish to speak? If not, I'll call on the Honourable Attorney General on his right of reply.
Thank you, Mr. Speaker, and thanks to the Honourable Member from Newland and, of course, the Honourable Minister for Financial Services for open support, their advocacy on this bill. Mr. Speaker, just to pick up where the Honourable Minister left off, I can confirm her observation that the government is currently looking at the, I don't know if I can call it emerging issue anymore because it's very much here, but that of virtual assets. And as we speak, work is underway in trying to craft appropriate legislative framework to take on board those concerns, observations made by the honorable member from Newlands. So we are working diligently on that, and at some stage the Legislative Assembly will have the benefit of that exercise and be able to debate the bill as it relates thereto. Mr. Speaker, just to pick up on one other comment made by the honorable member from Newlands, and that has to do in particular with his very astute observation about what was said in the report about the lack of sophistication to deal with money laundering prosecutions and the paucity, if I might put it that way, and the numbers of money laundering prosecutions. Mr. Speaker, he did say that we should push back on some of these things and to basically tell our story. And he's quite correct, Mr. Speaker. The problem is, as I identified in my earlier comments, which is that those who are critical of us don't seem to want to be confused by the facts, Mr. Speaker. And that's a difficulty we continue to face. Over the years, Mr. Speaker, I have endeavored to explain, and I did so, we did so again during the on-site inspection and during our ongoing engagements with CFATF and FATF. We have endeavored to explain, Mr. Speaker, that first of all, the observation about a lack of high number of money laundering prosecutions in Cayman is based on false assumptions, because that view is informed by the perception that because we are a high-risk jurisdiction, then there's an incredible amount of money laundering that must be taking place here. And so the question is, well, why don't you have more money laundering prosecutions? Well, as the honorable member says, it might very well be, and I'm not saying that's always the case, it might very well be that a lot of these things are not happening here to the degree that you think it is. Because, of course, you know, Mr. Speaker, we're still being viewed through the prism of the firm, that movie, The Firm. But in addition to that, Mr. Speaker, we have a very robust international cooperation framework, very robust international cooperation regime, where we partner with other jurisdictions in fighting transnational crime. Mr. Speaker, as part of that framework, we have treaties, a mutual legal assistance treaty. We have our main partner with the United States. Invariably, in the context of the Cayman Islands, Mr. Speaker, what we find is that in dealing with these matters, you might have an accused person who resides abroad, resides in another jurisdiction, and for argument purposes, just use the United States for the purpose of this discussion. As an example, might be residing in the United States. The accused person lives in the United States, commits a fraud. The persons who are defrauded or the institution is in the United States, so the witnesses are in the United States. The only thing that we have in the Cayman Islands might be a bank account and an entity that has been incorporated here, a company, which holds a bank account. So, Mr. Speaker, it is true that some element of the offense touches the Cayman Islands. But what we find is that the main player or players are in the other jurisdiction, the accused and the witnesses. And the only thing that is here is the account documents establishing the evidence in the opening of the account, and the documents that evidence the incorporation of the company. Mr. Speaker, in those circumstances, it is much easier for us to send the evidence, i.e. the documents, to the other jurisdiction. They prosecute the person in the United States, for example. It's far more convenient for them to do that. And at the end of that outcome, if there are assets to be shared, the United States, as they often do, share the assets with us. So we get part of the assets because we have an asset sharing agreement with them. That, Mr. Speaker, invariably explains why we have less money laundering prosecutions in the Cayman Islands. Because the main players are not here. The main players are elsewhere. All we have here is bank account and the incorporation documents. So we send the things to them, they prosecute it, and they send the share of the assets to us. There's no point launching a parallel prosecution here when it is far more convenient to prosecute in another country. And so when you explain those things to our detractors, Mr. Speaker, the refrain is, well, are you saying that you don't have an obligation to prosecute? We're not saying that at all. We couldn't properly be saying that. We're saying, as is recognized internationally, if the most convenient forum to prosecute the matter is in the other country where the witnesses and the accused person are, then clearly we do that by way of a partnership, and the matter is dealt with there. So, you will see over the years, Mr. Speaker, that we had extremely heavy traffic in terms of cooperation with these countries, with some of these countries, United States in particular. And they are not afraid to admit, they are on record as admitting, that we do work hand in hand with them in fighting transnational organized crime. We provide extraordinary assistance to them, and so on. So that explains some of the reason why we have less money laundering prosecutions in the Cayman Islands. And we really can't apologize for that, because that is how the world operates. You prosecute where it is more convenient, but as a treaty country, we have an obligation to assist in those prosecutions abroad by the provision of evidence and other things that we can provide for. So that explains it. And we have been, to answer his question, or to note his observation about we should push back and try to clarify, we do sometimes make those observations to them. But sometimes it works, sometimes they don't want to be confused by that at all, because it doesn't fit into the narrative that the Cayman Islands is a high-risk jurisdiction, and so we must be seen in a particular context. We are a sort of a rogue jurisdiction. That's the impression that they try to give sometimes and so on. But we continue to try. We continue to do what we're required to do, and we take pride in doing so, Mr. Speaker. Thanks. So, Mr. Speaker, that explains that, and I certainly wish to thank honorable members again for their support of the bill. Thank you.
Question is that a bill shortly entitled The Proceeds of Crime Amendment Bill 2019 be given a second reading. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The Proceeds of Crime Amendment Bill 2019 has been given a second reading. It's now reached the hour of 4:30. Premier, if you could move the suspension, and we'll go into committee stage thereafter.
Thank you, Mr. Speaker. Mr. Speaker, I move the suspension of Standing Order 10-2 in order that business may continue beyond the hour of interruption.
Question is that standing orders 10-2 be suspended in order to conduct business after the hour of 4:30. All in favor, please say aye. Those against, the ayes have it. The House will now go into committee. Please be seated. The House is now in committee, and with the leave of honorable members, we will assume that, as usual, we would authorize the Honorable Attorney General to correct minor errors in the bills. And so we'll move right into the bills. Clerk. Had that up and left it. Okay.
The Directors' Registration and Licensing Amendment Bill 2019. Clause 1, short title and commencement. Clause 2, amendment of Section 2 of the Directors' Registration and Licensing Law 2014, interpretation.
Question is that clauses 1 and 2 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clause 1 and 2 stands part of the bill.
A bill for a law to amend the Directors' Registration and Licensing Law 2014 to make a minor amendment to the definition of covered entity and for incidental and connected purposes.
Question is that the title do stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. The title stands part of the bill.
Securities Investment Business Amendment Bill 2019. Clause 1, short title.
The question is that clause 1 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clause 1 stands part of the bill.
Clause 2, amendment of Section 2, definitions. It's an amendment.
I think we have an amendment from the minister. Are you ready?
Yes, thank you, Mr. Speaker. Mr. Speaker, Mr. Chair, in accordance with the provision of Standing Order 52.1 and 2, I, the Honourable Tara Rivers, the Minister responsible for Financial Services and Home Affairs, give notice to move the following amendments to the Securities Investment Business Amendment Bill 2019, that the bill be amended as follows. by deleting clause 2 and substituting as follows. Quotes, amendment of section 2 dash definitions. 2, the Securities Investment Business Law 2019 revision, in this law referred to as the principal law, is amended in section 2 as follows. A, by deleting the definition of the words, quote, senior officer, quote, and substituting the following definition. Quote, quote, senior officer, quote, means a director, managing director, president, chief executive officer, partner, managing partner, general partner, ultimate partner, manager, or someone who has a similar control function, semicolon, end quote. And B, by inserting in the appropriate alphabetical sequence the following definitions. Quote, depository, end quote, means a depository appointed in accordance with paragraph 11 of the schedule to the Securities Investment Business, brackets, EU Connected Fund, brackets, Alternative Investment Managers Directive, brackets, Regulations 2016, and carrying out the duties set out in paragraph 3 of that schedule. Quote, registered person means, quote,
13.
paragraph 13 of that schedule. Yes, sorry, Mr. Speaker, Mr. Chair, if I said, yeah, it's paragraph, set out in paragraph 13 of that schedule. Quote, registered person, quote, means a person specified in Schedule 4 and who has registered with the authority in accordance with sections 5(4). Quote, single family, quote, in relation to a single family office means A, an individual, or B, a group of individuals who are connected in at least one of the ways set out in Schedule 4A. Quote, single family office, quote, means a legal entity or legal arrangement formed in the islands by a single family to conduct securities investment business for or on behalf of that single family where A, the securities are not beneficially owned by a third party, colon, and B, the legal entity or legal arrangement does not hold itself out to the public as conducting securities investment business for any person except members of the single family, semicolon, end quote.
Is the minister wishing to speak to the amendment?
Yes, Mr. Speaker, just briefly, the amendment modifies the definition of senior officer and single family. The modification of the definition of senior officer clarifies that the list as provided is not exhaustive, while the modification to the definition of single family makes it clear that an individual has been contemplated and is included.
Does any other member wish to speak? The question is that the amendment stands part of the clause. All those in favor, please say aye. Aye. Those against, the ayes have it. Amendment stands part of the clause. The question now is that clause 2, as amended, stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The clause as amended stands part of the bill.
Clause 3, amendment of section 4, meaning of securities investment business.
Honourable Minister, you have an amendment?
Yes, thank you. In clause 3, by deleting paragraph B and substituting as follows. Quote, B, by repealing section 2 and substituting the following subsections. Quote, 2, the respective activities carried out by the non-registrable persons described in Schedule 2A and the activities set out in Schedule 3 do not constitute the carrying on of securities investment business for the purpose of this law. 3, the persons described in Schedule 2A are persons who are not required to register under this law, quote, end quote.
Is the minister speaking further?
No, Mr. Speaker.
The question now is that clauses 3 as amended stand part of the bill. All those in favor? Sorry, the question is that clause 3 as amended, that the,
Slow down. Stop.
yes. Question is that amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The amendment stands part of the clause. Question now is that clause 3 as amended stands part of the bill. All those in favor, please say aye. Aye. Those against? The ayes have it. The clause as amended stands part of the bill.
Clause 4, insertion of section 2A, exercise of discretionary powers, 4B. Sorry. Clause 4, insertion of section 4A, exercise of discretionary powers, 4B, directions to cease and desist, and 4C, prohibition to act. Sorry. Prohibition to act as depository.
Yeah. Honourable Minister, you have an amendment?
Yes, thank you. In Clause 4, in the new subsection 4AA, by deleting the words, quote, at the time of registration, end quote, and substituting the words, quote, or licensing at the time of application or at any time thereafter, comma, as the authority may consider appropriate, having regard to the nature, comma, risk, and scale of the business, end quote.
The question is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The amendment stands part of the clause. The question now is that clause 4 as amended stand part of the bill. All those in favor?
Aye.
Those against? The ayes have it. Clause 4 as amended stands part of the bill.
Clause 5, amendment of section 5, requirement for a license.
Honourable Minister, you're amending?
Yes, thank you. In Clause 5 as follows. 1, by deleting paragraph C and substituting the following paragraphs. Quote, C, by inserting after subsection 1 the following subsections. Quote, 1A, an individual shall not carry on securities investment business in or from within the islands except where the individual is a person described in Schedule 2A. 1B, a person who carries on securities investment business activities for which a license or registration is required shall be A, a company incorporated under the Companies Law 2018 revision, B, a general partnership established under the Partnership Law 2013 revision, C, a limited partnership registered under the Partnership Law 2013 revision, D, an exempted limited partnership registered under the Exempted Limited Partnership Law 2018 revision, E, a foreign company registered under Part 9 of the Companies Law 2018 revision, F, a limited liability company formed and registered under the Limited Liability Companies Law 2018 revision, or G, a limited liability partnership formed and registered under the Limited Liability Partnership Law 2017, period, end quotes. CA, in subsection 2, by deleting the words, quote, Schedule 4, end quote, and substituting the words, quote, Schedule 2A, end quote, semicolon, close quotes. And in paragraph D as follows. A, in the new subsection 4B, by deleting the words, quote, the last business transaction in the islands, end quote, and substituting the words, quote, ceasing to carry on in the islands any regulated activity listed in Schedule 2, end quote. And in B, the new subsection C, by inserting after the words, quote, 21 days after any, end quote, the word quote, material, end quote.
Is the minister speaking further?
Mr. Speaker, just briefly, the amendment to the new subsection B seeks to clarify that the registered person would be required to notify SEMA of its intent to deregister within 21 days of ceasing to carry on a business or carry on as a business any security investment business activity on the islands. And the insertion of the word material to the new subsection 4C seeks to confirm that SEMA would not require notification that a change has occurred unless the change is deemed substantive.
Thank you. The question is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The amendment stands part of the clause. The question now is that clause 5, as amended, stands part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The clause as amended stands part of the bill.
Clause 6, amendment of section 6, application for a license.
Take the vote on that.
The question is that clause 6 do stands part of the bill. All those in favor, if nobody wishes to speak, please say aye.
Aye.
Those against? The clause stands part of the bill.
Clause 7, amendment of section 8, shares not to be issued or transferred without the prior approval of Clause 7, amendment of section 8, shares not to be issued or transferred without the prior approval of the authority.
The minister has an amendment.
Yes, thank you. In clause 7A, in the new subsection 1A, by inserting after the words, quote, or interest in, end quote, the words, quote, a limited liability company or, end quote.
The amendment has been moved. Does any member wish to speak thereto? The question then is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The amendment stands part of the clause. The question now is that clause 7, as amended, stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The clause as amended stands part of the bill.
Clause 8, amendment of section 9, use of words connoting securities investment business. Clause 9, amendment of section 10, segregation of property. Clause 10, amendment of section 12, guidance notes.
Question is that clauses 8 to 10 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The clauses 8 through to 10 stands part of the bill.
Clause 11, amendment of section 15, number and approval of directors.
Honorable Minister.
Yes, thank you. In clause 11C as follows. 1. In the new subsection 4, by deleting paragraph A and substituting the following paragraph. Quote, A. A company incorporated under the Companies Law 2018 revision, a minimum of 1, 2 directors who are individuals, or 2, 1 corporate director, each of whom is complying with the Directors' Registration and Licensing Law 2014, semicolon, end quote. And 2, in the new subsection 5, by deleting the words, quote, directors and, end quote.
The question is that clause 11, as that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The amendment stands part of the clause. The question is now that clause 11, as amended, stand part of the bill. If no one wishes to speak, then the question is that clause 11, as amended, stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The clause 11, as amended, stands part of the bill.
Clause 12, amendment of section 16, powers and duties of the authority. Clause 13, amendment of section 17, enforcement powers of the authority. Clause 14, amendment of section 18, injunctions and restitution and disgorgement orders. Clause 15, amendment of section 19, duty of auditor. Clause 16, amendment of section 21, winding up. Clause 17, amendment of section 22, appeal against decisions made under section 17, 2, 1, and 8. Clause 18, repeal of section 23, appeals against other decisions of the authority.
Question is that clauses 12 through to 18 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clauses 12 through to 18 stands part of the bill.
Clause 19, amendment of Schedule 2, securities investment business, regulated persons. Clause 20, amendment of Schedule 4, excluded persons.
Question is that clauses 19 and 20 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clauses 19 and 20 stands part of the bill.
Clause 21, transitional.
Honourable Minister.
Thank you. By deleting clause 21 and substituting the following clause, quote, transitional. 21, 1. Any person who is registered with the authority pursuant to paragraphs 1, 4, and 5 of Schedule 4 on the day immediately before the commencement of this law shall, A, provide such information as the authority may request by the 15th of August 2019, semicolon, and B, take such steps to re-register with the authority as a registered person by the 15th of January 2020, if that person wishes to continue carrying on securities investment business. 2, a person described under subsection 1 who, A, does not provide the required information to the authority by the 15th of August 2019, semicolon, or B, does not complete the re-registration process under this section by the 15th of January 2020, shall cease conducting securities investment business in or from within the islands and shall be deregistered by the authority, period, end quote.
The amendment has been duly moved. Does any member wish to speak thereto? Question then is that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The amendment stands part of the clause. The question now is that clause 21, as amended, stands part of the bill. No member wishes to speak. The question then is that clause 21, as amended, stands part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clause 21 as amended stands part of the bill.
A bill for a law to amend the Securities Investment Business Law 2019 revision to adjust the excluded persons regime and for incidental and connected purposes.
Question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The title stands part of the bill.
Proceeds of Crime Amendment Bill 2019, Clause 1, short title.
Honorable Attorney General.
Thank you, Mr. Chairman. Chair, in accordance with Standing Order 52.1 and 2, I, Honorable Attorney General.
AG, just a minute, please. Yeah.
You don't have an amendment to one. There's no amendment to one. You don't have an amendment to one.
Do you have an amendment? No.
Take the vote on one. Sorry, I had a
Before you move on, AG, the question is that clause 1 do stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause 1 stands part of the bill.
Clause 2, amendment of Section 2 of the Proceeds of Crime Law 2019 revision, interpretation.
Honorable AG.
Thank you, Mr. Chairman. Mr. Chairman, in accordance with the provision of Standing Order 52.1 and 2, I, Honorable Attorney General, give notice to move the following amendments to the Proceeds of Crime Amendment Bill 2019. One, that the bill be amended as follows. A, by deleting Clause 2 and substituting as follows. Quote, amendment of Section 2 of the Proceeds of Crime Law 2019 revision dash interpretation. 2, the Proceeds of Crime Law 2019 revision in this law referred to as the principal law is amended in Section 2 as follows. A, by deleting the definition of the word constable and substituting the following definition. Quote, constable, close quote, includes a person appointed as an investigating officer under the Anti-Corruption Law 2019 revision and a person appointed as an officer of Customs and Border Control under Customs and Border Control Law 2018. And B, by inserting the following definitions in the appropriate alphabetical sequence. Fiat currency means currency that is issued by the relevant body in a country or by a government that is designated as legal tender in its country of issuance through, among other things, government decree, regulation, or law. Quote, property investment, close quote, means dealing in land, including the sale or purchase of land or interest in land, as a business within the meaning of the Trade and Business Licensing Law 2019 revision. quote, single family office, close quote, means a legal entity or legal arrangements formed in the island by a single family to conduct securities investment business for or on behalf of that single family where A, the securities are not beneficially owned by a third party, and B, the legal entity or legal arrangement does not hold itself out to the public as conducting securities investment business for any person except members of the single family. Quote, supervisory authority, and close quote, means the monetary authority or other body that may be assigned pursuant to section 49, the responsibility of monitoring compliance with regulations made under this law in relation to persons carrying out relevant financial business who are not otherwise subject to such monitoring by the monetary authority. Semicolon. Quote, transfer, close quote, in relation to a virtual asset means conducting a transaction on behalf of a natural or legal person that moves a virtual asset from one virtual asset address or account to another, semicolon. Virtual asset means a digital representation of value that can be digitally traded or transferred, and can be used for payment or investment purposes, semicolon, and, quote, virtual asset, close quote, virtual asset service, close quote, means the business of conducting one or more of the following activities or operations for or on behalf of a person. A, exchanging between virtual assets and fiat currencies. B, exchanging between one or more other forms of convertible virtual assets. C, transferring virtual assets. D, safekeeping or administering virtual assets or instruments enabling control over virtual assets. And E, participating in and providing financial services related to an issuer, offer or sale of a virtual asset, close quote, and that's it.
The amendment has been duly moved. If no member intends to speak, question is that the amendment stand part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. Unless the AG is doing anything further, the clause, now the question would be, clause 2, as amended, stands part of the bill. If no member wishes to speak, then the question is that clause 2, as amended, stands part of the bill. All those in favor, please say aye. Those against, the ayes have it. The clause 2, as amended, stands part of the bill.
Clause 3, amendment of section 4 of the principal law, powers, functions, and duties of financial reporting authority.
There's an amendment to that.
Honorable AG. Took some candy.
Yeah, there's a new one, will come back, yeah. So,
Thank you, Mr. Chairman. In relation to, in accordance with the provision of Standing Order 52.1 and 2, I give notice to move the following amendment to the Proceeds of Crime Amendment Bill 2019, that the bill be amended by deleting clause 3 and substituting the following clause. Quote 3, the principal law is amended in section 4.2 by inserting after paragraph A the following paragraph. Quote, AA, bracket, in bracket, shall be provided with such information as may be prescribed, including cash transaction reports, wire transfer reports, and threshold-based declarations or disclosures where the information is required by law, comma, close quotations.
The amendment has been moved. Does any member wish to speak thereto? If not, the question then is that the amendment stand part of the clause. All those in favor, please say aye. Those against? The ayes have it. The amendment stands part of the clause. The question now is that clause 3 as amended stands part of the bill. No member wishes to speak. Question would be that clause 3 as amended stand part of the bill. All those in favor, please say aye. Those against? The ayes have it. Clause 3 as amended stands part of the bill.
Clause 4, amendment of section 5 of the principal law, anti-money laundering steering group.
Just take the vote on that.
Question is that clause 4 stands part of the bill. All those in favor, please say aye. Those against? The ayes have it. Clause 4 stands part of the bill.
Clause 5, amendment of section 139 of the principal law, tipping off.
It's amendment to that.
Honorable AG.
Thank you, Mr. Chairman. I give notice to move the following amendment, that the bill be amended in clause 5 by deleting paragraph A and substituting the following. A, in bracket, in subsection 1, subsection B, comma,
He's right here.
by inserting after the words,
Clause 3.
quote, in paragraph A,
Sorry, mark paper up.
A in bracket, comma, sorry, close quote, the words, open quote, bracket, whether or not investigation is conducted, close quote.
Question is, sorry, the amendment has been duly moved. Does any member wish to speak thereto? The question then is that the amendment stands part of the clause. All those in favor, please say aye. Those against, no. The ayes have it. The amendment stands part of the clause. The question now is that clause 5 as amended stands part of the bill. If nobody wishes to speak, then the question is that clause 5 as amended stands part of the bill. All those in favor, please say aye. Those against? The ayes have it. The clause as amended stands part of the bill.
Clause 6, amendment of section 201 of the principal law, regulations.
Take the vote on that.
Question is that clause 6 do stand part of the bill. All those in favor, please say aye. Those against? The ayes have it. Clause 6 stands part of the bill.
Clause 7, amendment of Schedule 6, activities falling within the definition of relevant financial business.
Amendment.
Honorable AG.
Thank you, Mr. Chairman. I give notice to move the following amendment, that the bill be amended in clause 7 as follows.
Sorry.
A in bracket, by deleting paragraph A and substituting the following paragraphs. A in bracket, in paragraph 14 as follows. Numeral 1, in the opening chapter, by inserting after the words estate agency, the words, quote, in bracket, including real estate agency or real estate brokering, close quote, and 2, by inserting after subparagraph B the following subparagraph, quote, in bracket, small ba, organization of contributions for the creation, comma, operation or management of companies, close quote, semicolon, and AA in bracket, small a, by inserting after paragraph 14 the following paragraphs. 14A, quote, undertaking property development within the meaning set out in section 2 of the Trade and Business Licensing Law 2019 revision, and the subsequent sale of that property without using a real estate agent or broker. 14B, undertaking property investment without using a real estate agent or broker. And B, by deleting paragraph C and substituting the following paragraph. Quote C, small c in bracket, by inserting after paragraph 20 the following paragraphs. Quote 21, providing virtual asset services. 22, operating a single family office, close quote.
The amendment has been duly moved. Does any member wish to speak? If not, the question then is that the amendment stand part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. Question now is that clause 7 as amended stands part of the bill. If no one wishes to speak, then the question is that clause 7 as amended stands part of the bill. All those in favor, please say aye. Those against, the ayes have it. The clause 7 as amended stands part of the bill.
New clause 2A.
New clause 2.
The AG.
Thank you, Mr. Speaker. Mr. Speaker, I beg, in accordance 52(1) and 2, I give notice to move the following amendment by B, by inserting after clause 2 the following clause. Quote, insertion of new section 2A, meaning of single family. Single family in quote unquote. The principal 2A, the principal law is amended by inserting after section 2 the following section. Quote, meaning of single family, close quote. 2A, 1, bracket. For the purpose of the definition of single family office, single family means A, an individual, semicolon, or B, a group of individuals who are connected in at least one of the ways set out in subsection 2, 2 in bracket, the following persons are connected persons in relation to an individual within a single family. A, spouse. B, the descendants of the individual and their spouses. C, parents, comma, including step-parents. D, grandparents. E, parents-in-law, including step-parents-in-law. F, brother, comma, step-brother, comma, sister, comma, step-sister, and their spouses. G, spouses, grandparents. H, spouses, brother, comma, step-brother, sister, comma, step-sister, and their spouses and children. I, parents, brother, comma, step-brother, comma, sister, comma, step-sister, and their spouses. J, children of the brother, comma, step-brother, comma, step-sister or step-sister of the individual's parents, comma, both present and future, comma, including stepchildren, comma, and their spouses, semicolon, and K, children of the individual's brother, comma, stepbrother, comma, sister or stepsister, comma, both present and future, including stepchildren and their spouses. 3, for any of the relationship listed in subsection 2 that may be established by blood, comma, that same relationship may also be established by adoption. 4, in subsection 2b, the term descendants of the individual means the individual's children, the children of that individual's children, the children of those children, and so on. And 5, for the purpose of subsection 4, the term children includes stepchildren.
New clause 2A, meaning of single family.
Yeah.
The question now is that this clause be read a second time. All those in favor, please say aye. All those in favor, please say aye. Those against? The ayes have it. The clause is deemed to have been read a second time. Question is that this clause be added to the bill as clause number 2A, and that the subsequent clauses be renumbered accordingly. All those in favor, please say aye. Those against? The ayes have it. Clauses 2A is added to the bill.
I don't order paper. You got suspense on orders. You have the suspense on the
No,
orders.
motion is on there.
No, not that one.
Which one?
Another one here.
New clause 5A.
AG.
Joe is?
No, the other one. Because it's like motion.
Honorable Attorney General.
Thank you, Mr. Speaker, Mr. Chairman. Thank you. I beg to give notice to move the following amendment. That the bill be amended in clause 5. That the bill is be amended by inserting after clause 5 the following new clause. Quote, insertion of new section 199A / power supervisory authority to enter, comma, search, etc. 5A. Principal law is amended by principal law here is the procedure crime law, is amended by inserting after section 199 the following section. Quote, power of supervisory authority to enter, search, etc. 199A1, where the supervisory authority reasonably suspects or is informed that a person who is required to comply with regulation 55F of the Anti-Money Laundering Regulation 2018 revision has not complied. An appropriate officer may lay before a magistrate or a justice of the peace an information on oath setting out the grounds for the suspicion and apply for the issue of a warrant for search to search the premises. 2, where an application is made under subsection 1 for a warrant, the magistrate or justice of the peace may issue a warrant authorizing the appropriate officer to enter upon the premises and search and inspect the premises with such assistance, comma, including assistance from a police officer, and by such force as is necessary and reasonable, comma, and to A, examine, inspect, make copies of, seize, or remove any document or record that the appropriate officer or police officer has reasonable grounds to believe is evidence of the contravention, semicolon, and B, seize any equipment or other property found on the premises in the course of the search that the appropriate officer or police officer has reasonable grounds to believe is being used in contravention of regulation 55F close code, and
He finished.
Yes. It's all right.
New clause 5A, power of supervisory authority to enter, search, etc.
This is clause
Yes,
renumbered to
no, 5E.
5A. The question now is that this clause be read a second time. All those in favor, please say aye. Those against? The ayes have it. The clause is deemed to have been read a second time. The question is that this clause be added to the bill as clause number 5A, and that the subsequent clauses be renumbered accordingly. All those in favor, please say aye. Those against? The ayes have it. Clauses 5A is added to the bill.
A bill for a law to amend the Proceeds of Crime Law 2019 revision to provide for the inclusion of the Anti-Corruption Commission in the Anti-Money Laundering Steering Group, and to provide for the inclusion of virtual service providers in the law, and to address other deficiencies in the compliance framework and for incidental and connected purposes.
Yes.
The question is that the title be
Stand part of the bill.
Question is that the title stands part of the bill. All those in favor, please say aye. Those against? The ayes have it. The title stands part of the bill. The House. All those in favor? Those against? The ayes have it. The bills will be reported to the House.
We go back to
The Assembly now resumes its sitting. Please be seated.
Report on bills. The Directors' Registration and Licensing Amendment Bill 2019.
The Honourable Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I am to report that a committee of the whole House has considered the bill shortly entitled the Directors' Registration and Licensing Amendment Bill 2019, and it was passed without amendment.
Bill has been duly reported and is set down for the third reading.
The Securities Investment Business Amendment Bill 2019.
The Honourable Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I am to report that a committee of the whole House has considered the bill shortly entitled the Securities Investment Business Amendment Bill 2019, and it was passed with amendment.
Has been duly down for the third reading.
Proceeds of Crime Amendment Bill 2019.
The Honourable Attorney General.
thank you, Mr. Speaker. Mr. Speaker, I beg to report that the bill, the short title of which is the Proceeds of Crime Amendment Bill 2019, has been considered by a committee of the whole House and passed with several amendments.
The bill has been duly reported and is set down for the third reading. To come.
Mr. Speaker, I beg to move the suspension of Standing Order 47 in order that bills can be taken through 3 readings in the course of one sitting.
Question is that Standing Order 47 be suspended in order to take the bills all through stages. All in favor?
Aye.
Those against? The ayes have it. Standing Order 47 is suspended.
Third readings, the Director's Registration and Licensing Amendment Bill 2019.
The Honorable the Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the bill shortly entitled the Director's Registration and Licensing Amendment Bill 2019 be read a third time and passed.
The question is that a bill shortly entitled the Director's Registration and Licensing Amendment Bill 2019 be given a third reading and passed. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The Director's Registration and Licensing Amendment Bill 2019 has been read a third time and is passed.
The Securities Investment Business Amendment Bill 2019.
The Honorable the Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move the bill shortly entitled the Securities Investment Business Amendment Bill 2019 be read a third time and passed.
The question is that a bill shortly entitled the Securities Investment Business Amendment Bill 2019 be given a third reading and passed. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The Securities Investment Business Amendment Bill 2019 has been read a third time and is passed.
The Proceeds of Crime Amendment Bill 2019.
The Honorable the Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that a bill short title, which is the Proceeds of Crime Amendment Bill 2019, be given a third reading and pass. And before I take my seat, I just crave indulgence to thank the Legislative Drafting Department and Mr. Lawrence from my Anti-Money Laundering Unit for assisting with the bills. Thank you very much.
The question is that a bill shortly entitled the Proceeds of Crime Amendment Bill 2019 be given a third reading and passed. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The Proceeds of Crime Amendment Bill 2019 has been read a third time and is passed.
Motions. Government Motion Number 4 of 2018-19, Amendment to the Development Plan 1997, Proposed Rezoning, to be moved by the Honourable Minister of Commerce, Planning and Infrastructure.
The Honourable the Minister of Planning.
No. Thank you, Mr. Speaker. Mr. Speaker, I beg to move Government Motion Number 4, 2018-2019, Amendment to the Development Plan 1997. And Mr. Speaker, with your permission, I'll take a very deep breath and read the motion.
Question is, where is the motion? The Honorable the Minister of Planning.
Thank you, Beach South, Block 12C, Parcel 3. West Bay Beach South, Block 12C, Parcel 517 as Parcel 517, formerly a section of Block 12C, Parcel 2. West Bay Beach South, Block 12C, Parcel 393. West Bay Beach South, Block 12C, Parcel 451, formerly Block 12C, Parcel 394. Whereas, on June 4th, 2008, CPA 1908, Item 4.3, the Central Planning Authority, the CPA, originally considered the request to amend the development plan from neighborhood commercial, low-density residential, and mangrove. It was resolved to include adjacent properties to the north up to the existing hotel tourism zone into the proposal to prevent spot zoning. But Block 12C, Parcel 203, was removed from the proposal. The new proposal therefore became an application for the rezoning of registration section West Bay Beach South, Block 12C, Parcel 3, from neighborhood commercial, low-density residential, and mangrove buffer to hotel tourism and mangrove buffer. Registration section West Bay Beach South, Block 12C, Parcel 517, from neighborhood commercial to hotel tourism. Registration section West Bay Beach South, Block 12C, Parcel 393, from neighborhood commercial to hotel tourism. Registration section West Bay Beach South, Block 12C, Parcel 451, from neighborhood commercial, public open space, and mangrove buffer to hotel tourism and mangrove buffer. And whereas the proposed amendments were in accordance with Section 11.2 of the Development and Planning Law 2005 revision, and persons were invited to view the application at the Department of Planning for comment. During the 60-day comment period, 12 letters of objections were received on the proposed amendment. And whereas on the 4th of March 2009, CPA 0709, Item 4.1, the Central Planning Authority again considered the proposal, and in light of the objections received, considered the proposal, and in light of the objections received, and it was resolved to forward the rezone application for their recommendations in accordance with Section 11.3A of the Development and Planning Law 2005 revision. And whereas on the 26th of June 2015 and the 12th March 2017, the Planning Appeals Tribunal, sitting as the Development Plan Tribunal, heard the rezone proposal in light of the objections. And whereas on the 16th of May 2017, the DPT issued its report to the CPA recommending that Block 12C, Parcel 393 and 451 be rezoned to hotel tourism with the retention of the mangrove buffer zoning. They also recommended that Block 12C, Parcel 517 and the section of Block 12C, Parcel 3 that is sandwiched between West Bay Road and the Esterly Tibbetts Highway be rezoned to the hotel tourism zone. The DPT, however, disagreed with the proposal to rezone Block 12C, Parcel 518, and the section of Block 12C, Parcel 3, sandwiched between the Esterly Tibbetts Highway and the North Sound coast, and instead recommended that this land should remain in their present zoning of low-density residential and mangrove buffer. And whereas on the 30th of August, the initial decision made on the 3rd of December 2008, which was to extend the hotel tourism zone from West Bay Road east to the mangrove buffer on the North Sound coast over all parcels of the proposal, and that Block 12C, Parcel 203, should remain as presently zoned and serve as a buffer to the residents of Canal Point development. At this meeting, it was therefore resolved to forward the application to the Ministry of Commerce, Planning and Infrastructure for onward transmission to the Legislative Assembly for consideration. And whereas on the 26th March 2019, Cabinet considered the rezoning proposal and approved that the matter be submitted to the Legislative Assembly for consideration. Be it now therefore resolved that in accordance in Section 10.2b of the Development and Planning Law 2017 revision, the Central Planning Authority hereby recommends and submits to the Legislative Assembly the following proposal for alteration to the Development Plan 1997, a summary and map of which are attached hereto. And be it further resolved to alter the zoning area of registration section West Bay Beach South, Block 12C, Parcel 3, from neighborhood commercial, low-density residential, and mangrove buffer to hotel tourism and mangrove buffer. Registration section West Bay Beach South, Block 12C, Parcel 517, from neighborhood commercial to hotel tourism. Registration section West Bay Beach South, Block 12C, Parcel 518, from low-density residential to and mangrove buffer to hotel tourism and mangrove buffer. Registration section West Bay Beach South, Block 12C, Parcel 393, from neighborhood commercial to hotel tourism. And registration section West Bay Beach South, Block 12C, Parcel 451, from neighborhood commercial, public open space and mangrove buffer to hotel tourism and mangrove buffer.
Question is that be it now therefore resolved that in accordance in Section 10.2b of the Development and Planning Law 2017 revision, the Central Planning Authority hereby recommends and submits to the Legislative Assembly the following proposal for alteration to the Development Plan 1997, a summary and maps of which are attached hereto. And be it further resolved to alter the zoning area of registration section West Bay Beach South, Block 12C, Parcel 3, from neighborhood commercial, low-density residential, and mangrove buffer to hotel, tourism, and mangrove buffer. Registration section, West Bay Beach South, Block 12C, Parcel 517, from neighborhood commercial to hotel, tourism. Registration section, West Bay Beach South, Block 12C, Parcel 518, from low-density residential and mangrove buffer to hotel, tourism, and mangrove buffer. Registration section, West Bay Beach South, Block 12C, Parcel 393, from neighborhood commercial to hotel, tourism. Registration section, West Bay Beach South, Block 12C, Parcel 451, from neighborhood commercial, public open space, and mangrove buffer to hotel, tourism, and mangrove buffer. The motion is now open for debate. Honorable Minister of Planning.
Thank you, Mr. Speaker. Mr. Speaker, I'll try to offer some further clarity on quite a windy motion. Mr. Speaker, in accordance with Section 10.2 of the Development and Planning Law 2017 revision, I wish to lay on the table of this Honorable House a proposal to change the zoning of land belonging to registration section West Bay Beach South within Block 12C, Parcels 3, Block 12C, Parcels 517, formerly a section of Block 12C, Parcel 2, Block 12C, Parcel 518, formerly a section of Block 12C, Parcel 2, and Block 12C, Parcels 393, and Block 12C, Parcels 451, formerly Block 12C, Parcel 394. Mr. Speaker, members will find in the information before them related to the rezone submission the following: a written summary of the rezoning application, a map illustrating the location of the proposed rezone submission and the existing zoning over the land, and finally, a map illustrating the proposed zoning of the submission being discussed. So, Speaker, the lands as mentioned in the motion have a variety of zones, which are neighborhood commercial, public open space, low-density residential, and the mangrove buffer along the North Sound coast. The proposal is simply to alter the zoning of these lands to allow the enhancement of our tourism product within the 7 Mile Beach area and to retain the existing mangrove buffer in its current form. Mr. Speaker, the motion read earlier was very detailed and contained many of the pertinent points of this application. So, Mr. Speaker, my brief presentation of this submission, I hope to summarize and clarify rather than reiterate the details clearly presented in the motion. Mr. Speaker, the land being discussed today are the vacant parcels located just north of the redeveloped Coconut Center off West Bay Road, which Eduardo's Restaurant and a number of residential and commercial units are located within. The rezone area then extends north to the landside section of the Ritz-Carlton Hotel site, then east to include the Ritz Golf Course and their long-term residential offerings towards the North Sound, and the south finally to the vacant land just below the Island Heritage Roundabout. Mr. Speaker, from the initial application hearing in 2008, the Central Planning Authority, the CPA, removed Block 12C, Parcel 203 from the rezoning proposal in support of creating a buffer for the nearby residents of Canal Point. This land is to remain in its current zoning of low-density residential and is to form a less intensive buffer in future developments that will be used to mitigate the difference in scale between existing residential developments and future uses. Mr. Speaker, the CPA also supported the concept that the land sandwiched between the existing hotel tourism zone to the north that currently exists over parts of Crystal Harbor and the North Sound Golf Club should be extended downwards to connect with the new proposal. This would prevent more residential developments being sandwiched by hotel developments without the owner's foreknowledge of the area's long-term vision. Further to this, Mr. Speaker, in processing the application, it was also discovered that the Ritz-Carlton had previously applied for a rezone in 1997, but the file was lost in Hurricane Ivan, and there was no record that the rezone was ever completed. Mr. Speaker, the new conglomerate of land related to the rezone was then advertised in accordance with the D&P law between the 16th and the 24th of December 2008, and objections were received from residents in the area. On the 26th of June 2015 and the 12th of March 2017, an active planning appeals tribunal, the PAT, sitting as a development plan tribunal, the DPT, was finally able to hear the rezoning proposals in light of the residents' objections. On the 16th of May 2017, the DPT issued a report for the CPA's consideration, which occurred at the CPA meeting on the 30th of August 2017 with the objectors. In summary, the PAT recommended that the whole Ritz-Carlton site be changed to hotel tourism and mangrove buffer zoning. Further south, however, they suggested that only the land sandwiched between the West Bay Road and the Esterly Tibbetts Highway should be rezoned to hotel tourism. The land south of the Ritz-Carlton, sandwiched between the Esterly Tibbetts Highway and the North Sound coast, should, in their opinion, remain in its present zoning of low-density residential and mangrove buffer. In this meeting, the CPA, however, reconfirmed their support of their initial decision made on the 3rd December 2008, which was to extend the hotel tourism zone from West Bay Road east to the mangrove buffer on the North Sound coast as initially advertised. The authority also reconfirmed that Block 12C, Parcel 203, should remain as presently zoned and serve as a buffer to the nearby Canal Point residents. At this meeting, it was resolved to forward the application to the Ministry of Commerce, Planning and Infrastructure for onward transmission to the Legislative Assembly for consideration. Mr. Speaker, in briefly touching on the concerns raised by the nearby residents, the PAT and the CPA, all parties agree that hotel and tourism uses are suitable for this area. The main debate is centered on the amount of land that should act as a buffer for the change in land uses. It should also be noted, Mr. Speaker, that any future development of these sites must attain planning permission on their own merits, and any investigations or concerns related to those applications will be considered by the Central Planning Authority at that time. In relation to the debate on the buffer concept, the PAT supports a view that the hotel uses should remain approximately 700 feet from the existing residence, and the CPA supports that a distance of 100 feet is suitable. Both views have their merit, but there are a few nuances that give credence to the CPA's position and should be expressed. Mr. Speaker, we live on a small island mass where large buffers between differing uses are expensive propositions. Furthermore, Mr. Speaker, no matter the distance, these lands will not simply remain sterile and undeveloped territories. They will eventually be developed as low-density subdivisions as zoned presently, and the proposed buffer will be eroded until residential developments once again adjoin hotel uses, while missing the opportunity to densify the area appropriately. At the 100-foot buffer mark created by the removal of Block 12C, Parcel 203 from the rezoning proposal, the CPA leaves a suitable green zone between the Canal Point residents and any future developments to the north. Due to its narrow shape, its future development potentials should be limited to building of similar massing and character as found in the residential subdivision itself. So, Mr. Speaker, I am pleased to say that on the 26th of March 2019, Cabinet considered the rezoning proposal and approved that the matter be submitted to the Legislative Assembly for consideration. So, Mr. Speaker, in closing, I ask for support of this Honorable House to approve Registration Section West Bay Beach South, Block 12C, Parcel 3, from neighborhood commercial, low-density residential, and mangrove buffer to hotel tourism and mangrove buffer. Registration Section West Bay Beach South, Block 12C, Parcel 517, which is formerly a section of Block 12C, Parcel 2, from neighborhood commercial to hotel tourism. Registration Section West Bay Beach South, Block 12C, Parcel 51A, which is formerly a section of Block 12C, Parcel 2, from low-density residential and mangrove buffer to hotel tourism and mangrove buffer. And Registration Section West Bay Beach South, Block 12C, Parcel 393, from neighborhood commercial to hotel tourism. And finally, Mr. Speaker, Registration Section West Bay Beach South, Block 12C, Parcel 451, which is formerly Block 12C, Parcel 394, from neighborhood commercial, public open space, and mangrove buffer to hotel tourism and mangrove buffer. Thank you, Mr. Speaker, and I hope that I was able to offer some insight to what is quite a lengthy and somewhat in-depth bill. Thank you, Mr. Speaker.
Does any other member wish to speak? The Honorable, the Leader of the Opposition.
Thank you, Mr. Speaker. Mr. Speaker, my history in this House tells all of us that I have never supported piecemeal rezoning. And if we do, my support is for doing it all where it can benefit particularly those generational Caymanians who own those properties. Mr. Speaker, there are a number of things that I find quite peculiar with this application, and I think I need to bring it to the attention of the government to see if it can be, my questions can be answered to my satisfaction. Now, Mr. Speaker, let us start with the fact that we are currently in the middle of a review of the development plan. And this rezoning seems quite peculiar that it would come now when we're trying to determine how and the land use, may I say, should be for future generations for a very long time, because the last time we did that was in 1997. Prior to that, in 1977, it was supposed to have been done over 5 years, and we have failed miserably in fulfilling that requirement, that legal requirement. Mr. Speaker, the other peculiarity with it is that it has taken so long to reach here. 2008. And for various reasons, I understand all that. Because it seems like it was parked because of certain objections having been made there too. That, I believe, is the biggest reason why it has been so delayed. But I'm going to demonstrate why these piecemeals and delays in rezoning is not a good thing. Mr. Speaker, the other peculiarity about this is that the appeals tribunal upheld the objector's case. And I see no place where the CPA appealed that. I see no indication that they have appealed that. And the question is, why not? After all this time, it now finds its way here after they have reconsidered it and sent it on to Cabinet. Why, or where is the indication, or where is the evidence that those objectors were given natural justice? In that, and it may be, Mr. Speaker, that the Attorney General will tell us that there's no necessity for the CPA to appeal that. Certainly, if the objectors had lost, they would have that avenue to appeal, thus holding it up that much longer. So I wonder if it is not the fact that the government, i.e. the CPA, since their proposals were not successful, I wonder if they're not required to appeal that too to the courts, because nothing has been said about that. Mr. Speaker, we see each day the results of the people not receiving natural justice in this country. We see it along West Bay Beach, where the public is crying out for the access, the public right-of-ways to be registered. We see a classic and current example of it playing out right before our very eyes. That is the rezoning, on the matter of the rezoning, right in Bodden Town out in Beach Bay. And people are getting concerned. We see, similar to that, where people are living in these areas and they are predominantly residential. When the zoning next to it will allow things like chicken farms with 20,000 to 30,000 chickens. These are the result of the absence of natural justice for people. Mr. Speaker, the lack of properly rezoning these things through the proper process and piecemealing them, the result is that the minister just got up here and told us that part of this is public open space, and we are now going to rezone that. Yet, we have the rich residences on public open space, which is not supposed to happen. And this is after the fact. That is the result of improper zoning. And the piecemealing and the delays that these things go through. Mr. Speaker, mind you, we all know that the West Bay Road has become an alien planet to the rest of Cayman anyway, and it's primarily tourism related. Visitors and development for that matter. And the land use there is primarily tourism related. So certainly we can appreciate the desire for people to get the zoning change from commercial and the likes to tourism, hotel tourism. And we all can appreciate that, Mr. Speaker, on that West Bay Road. But my concern is that this was done since 2008-9, somewhere in that area. And it was objected to. 12 people objected to it. Now, Mr. Speaker, if they did not have legitimate objections, it would never have reached the DPT. So, they have to be given. It would never have reached the DPT where their objections were successful. And almost 10 years hence, the CPA the Planning and Appeals Tribunal and the Department of Planning Tribunal heard this in March of 2017. And recommended the 2 parcels not be rezoned. They disagreed with Block 12C Parcel 518 and 12C Parcel 3, upholding the appeals of the appellant or their objection, the objectors, the position of the objectors. And then in August, the Central Planning Authority considered the proposal again in light of the Department of Planning Tribunal, mine is their tribunal report, and the objectors' comments. And the CPA reconfirmed their support of the initial decision made on the 3rd of December 2008. Mr. Speaker. And then, Mr. Speaker, they forwarded the application to the Ministry of Commerce, Planning and Infrastructure for onward transmission to the Legislative Assembly for consideration. And then in March of this year, the Cabinet approved it. Mr. Speaker, that's the only evidence we have before us. There is nothing saying whether the objectors were again notified or the objectors subsequently withdrew their objection. We don't know, but we are expected to vote on it. We are expected to approve it. In the absence of some indication as to what transpired during that period and where those objectors fell off that cliff, fell off that precipice, then I don't think we can support this motion to rezone in their mind. Mr. Speaker, as I said, when you look at it from the full picture, it is only natural that that area be zoned tourism from that perspective. But when you get people in residential areas objecting to it in that manner, and there are what are you saying? Mr. Speaker, we can't expect that, and Mr. Speaker, maybe the Attorney General can explain to me and convince me that what I'm saying is incorrect. But the law can't allow certain processes and people avail themselves to those processes and then followed in accordance with the law, and they're held to be legal or right, and then somehow they get circumvented. That confuses me. Me trembling? Oh, no, Bobo. Not today. Mr. Speaker, well, Mr. Speaker, the shakiness of the argument, well, somebody needs to explain it. I admitted that. I'm no lawyer, Mr. Speaker. But it can't be that we are giving people the right to appeal. They appeal and they win, and there is no evidence to suggest that the other side didn't appeal that win to be able to reach this point where they reconsider and move ahead with doing the same thing they had recommended. There is no evidence to suggest that. Well, that's what we need to know. Yeah, it could be, Mr. Speaker. I agree with you, sir, that it could be that the appellants are not the objectors are not ones to appeal. I don't know. Well, if we can say that they objected, we can say that, and we can say that the tribunal upheld their objection, then we can say that they lost the appeal too. Thus, that is why it's here. That's all I'm saying. Mr. Speaker, and then the minister tells us that they're leaving a buffer with the buffer zone, and they're leaving 100 feet along the boundary. The buffer zone doesn't provide any protection for the people in Canal Point. Absolutely not. It is at the maximum 200-300 feet right at the end of that road. The buffer zone goes along the North Sound. Mangrove, that's a mangrove, that's what we're talking about, the mangrove buffer. Mr. Speaker, the minister did. I see the 100 feet that they're leaving there, or whatever that buffer zone is that they're leaving there, but the mangrove buffer does not protect the residents in there, like we are saying in this case. Because, Mr. Speaker, you know the irony of mangrove buffers are that Section 18 of the law gives the planning authority full jurisdiction over the mangrove buffers. Full jurisdiction. You can't do anything. Development is prohibited in those areas. Section 18(2) of the regulation says all forms of development shall be prohibited in a mangrove buffer zone except in exceptional circumstances and only where equivalent storm protection is provided by some other means and it can be demonstrated to the authority that the ecological role of the peripheral mangroves will not be substantially adversely affected by the proposed development. So, mangrove buffers are naturally controlled by us. Mind you, Mr. Speaker, I am not one to believe that the mangrove buffers protects us from storm, because we saw how Hurricane Ivan just wiped them out and then the last time. And Mr. Speaker, my good friend Kurt Tibbetts and I were on planning, and the then government had asked next door to this, the people out of Jamaica that had the lease there. No, next door to the Ritz. Matlans. One of the conditions were that they were supposed to buy mangrove zone buffer elsewhere, and when my good friend Kurt Tippett and I understood that the late Nixon, Kirkland Nixon, was looking land for a botanic park. Kurt and I said, well, why are we asking them to go buy mangrove buffer elsewhere? Let's bring them in and tell them to go purchase a piece of land north side, thus the botanic park. Because you still have control over it, Mr. Speaker. You don't need to buy it. Government does not need to buy any buffer, any mangrove buffer. We have total control over it. Mr. Speaker, I do not want to stand in the way of development that is reasonable, especially along the West Bay Road. I said that now is alien to us. It has already gotten out of hand. We already lost control over that, and it's tourist related. It looks like the the South Beach in Miami and other beaches elsewhere in developed countries. The difficulty is that, and the problem was way back when, our own people sold the land when they should have been, and I understand, Mr. Speaker, not in their wildest dream they ever thought that West Bay Beach would become what it has become. But nowadays, we don't need to sell it any longer. We can have equity in whatever development is being placed on it. Mr. Speaker, I want to help the government, but I certainly want someone to tell us what happened to the objectors. Have they just gone to sleep? Have they just given up their property and migrated elsewhere? Have they acquiesced now to the CPA making confirming their original recommendation? And one of the resolve, Mr. Speaker, I'm a little puzzled with is that CPA submits this to this Parliament. CPA has no place to submit anything here. They recommend to Cabinet. Cabinet recommends to this legislature. Mr. Speaker, I know that it's somewhat concerning well, Mr. Speaker, I may have been wrong in that Section 10 does say that it is at least every 5 years after the date on which the development plan for any area is approved by the legislative assembly, the authority shall carry out fresh survey of that area and submit to the legislative assembly a report of the survey together with proposals for any alteration or additions to the plan. certainly, Mr. Speaker, I guess it goes to Cabinet only because no legislative assembly member is in planning, but it's Cabinet who brings it here. And I believe in the spirit of that, it does not mean directly to Cabinet, to the Legislative Assembly. So if that's the way the wording come from, it must be Cabinet, forward it to the Legislative Assembly. Mr. Speaker, I believe if the Attorney General can help us in this regard, I would be most grateful. And I guess I've confused him too, but I'm confused as to where these objectors are. If they have given up, that's fine. Then the members of this honorable House can vote their conscience as to whether or not they want the piecemeal, or they view it, as I said, along West Bay Road, that's what needs to happen. But I submit to the government to be careful with these things, because 2008, that rezoning submission was made for 451, I think it is, where the Ritz-Carlton residences are now. And 451, which included public open space. And right now, that public open space is developed. Those are the things that we need to look at, because those can cause all manner of objections and legal wrangling about whether the government has acted properly on behalf of the people, because public open space is only for recreational purposes, with development to assist that. Mr. Speaker, I wish to rest my case, but I trust that the government will, the minister can answer those few questions. Thank you.
Does any other member wish to speak? Does any other member wish to speak? The Honorable Minister of Planning, call on his right to reply.
Thank you, Mr. Speaker. Mr. Speaker, I will do I thank the Honorable Leader of the Opposition for his comments and observations, and I certainly will do my best to try and add some clarity. Mr. Speaker, the Honorable Leader of the Opposition is absolutely right, and I thank him for pointing out that we have not had a review of the National Development Plan for well over a decade. And I'm also happy to stand here to say that this government is in the process of carrying out a National Development Plan. 2 decades. Plan came on, and just to also explain that the way we are doing it, as the Honorable Leader of the Opposition pointed out, the law calls for the plan to be reviewed every 5 years. And so we have broken the island up into 5 zones, and we'll do 1 zone each year. And I do believe that one of the reasons why it had not been carried out over 2 decades was that it was too much of an ambitious task to try and do it all at once, and perhaps the budget or the will was not there. But by doing 1 zone every year, we will cover the entire island every 5 years, and we will start right over again. The Honorable Leader also highlighted the fact that this process, this particular rezoning had been going on for quite some time, for many years. And in fact, this is the second time around with an application being done in 1997, but with the files being lost in Hurricane Ivan, there was no record of what the result of the application was or whether it had actually came to a decision. The process for the member on the appeals, the Planning Appeals Tribunal, first of all, Mr. Speaker, the reason why this particular process had taken so long was that the Planning Appeals Tribunal had not been meeting regularly. And so the process had gotten lost, or there were quite a few appeals in the backlog, and in fact, quite a few of these rezonings within the ministry itself that we're just now getting caught up on. But the way the PAT works is that it actually reviews the CPA's decision. It's meant to be an independent review, so it's not your regular appeals tribunal. It reviews the CPA's decision and then writes a report to the CPA, which it did. And I think that's as a honorable leader of the opposition expressed some confusion in the matter. They did write the report, and as I said, on the 16th of May 2017, they issued the report for the CPA's consideration, which occurred at the CPA meeting on the 30th of August 2017. And I also went on to say that in that meeting, the objectors were present. So the objectors were present at the meeting on the 30th of August 2017. Mr. Speaker, I also just want to touch on saying that the honorable leader of the opposition is absolutely correct that we do want to look at the big picture. When you do look at the big picture of this rezoning, it's very obvious that that area and the area that rezoned for hotel tourism is prime for hotel tourism. The buffer that the report speaks to, the rezoning speaks to, is not between the residents of Canal Point and the rezoned area, is not the mangrove buffer, it's a residential zoning buffer. So the area, the one zone they left was residential zoning. And when we speak about the big picture, as the leader of the opposition said, even if they had left 700 feet or given 700 feet residential zoning or low density zoning, then what you would have happening is you would have low density residential built right up again to the hotel zoning, and we'd be right back in the situation where we have persons complaining or issues where you have hotel commercial zoning and residents built right up against that. With this narrow strip there, and I do believe that there is a plan forthcoming for a development there that will actually add a canal between the properties. With that zoning there, with the 100 feet residential lot that was left zoned for low density, then persons going in there will understand and know in advance that the property next door is zoned for hotel commercial. So I think this is actually the best way to achieve, and that is what the CPA were trying to achieve in their ruling, that the entire area now being zoned, because remember, Mr. Speaker, the original application was only for the area adjacent to the Ritz-Carlton golf course, and the CPA felt that it was in the sense of not piecemealing, as the leader of the opposition stated, that it made no sense to piecemeal and do that one piece and not take the zoning down. And as the leader of the opposition said, look at the big picture and extend the zoning along that entire area. So, Mr. Speaker, as I said, this was forwarded on to the ministry. We are catching up on several of these. I think the last time we were in session, I brought one as well. We have a couple more to come. And I feel confident that the CPA took into consideration the bigger picture, as that phrase has been coined this evening, in making this decision. And so, Mr. Speaker, again, I thank the Leader of the Opposition for his comments and his points. Some of them we are addressing in the review of the National Development Plan. But on this particular motion today, I thank him and I look forward to the government's support and in fact, the support of the entire House. Thank you.
Question is, be it now therefore resolved that in accordance in Section 10(2)B of the Development and Planning Law 2017 revision, the Central Planning Authority hereby recommends and submits to the Legislative Assembly the following proposal for alteration to the Development Plan 1997, a summary and maps of which are attached hereto. And be it further resolved to alter the zoning area of registration section West Bay Beach South, Block 12C, Parcel 3, from neighborhood commercial, low density residential and mangrove buffer to hotel, tourism and mangrove buffer. Registration section West Bay Beach South, Block 12C, Parcel 517, from neighborhood commercial to hotel tourism. Registration section West Bay Beach South, Block 12C, Parcel 518, from low density residential and mangrove buffer to hotel tourism and mangrove buffer. Registration section West Bay Beach South, Block 12C, Parcel 393, from neighborhood commercial to tourism to hotel tourism. Registration section West Bay Beach South, Block 12C, Parcel 451, from neighborhood commercial, public open space, and mangrove buffer to hotel tourism and mangrove buffer. All those in favor, please say aye. Aye. Those against? The ayes have it.
Mr. Speaker,
The member from Bordentown West.
can I have a division, please?
I heard no no's, but I'll give that you can have a division.
Honorable Alden McLaughlin,
Aye.
Honorable Sister Colonel, Honorable Juliana Connolly, Honorable Dwayne Seymour,
Aye.
Honorable Roy McTaggart, Honorable Joseph Hugh,
Aye.
Honorable Tara Rivers, Honorable Barney Bush, Captain Eugene Ebanks,
Aye.
Ms. Barbara Connolly,
Aye.
Mr. David White,
Aye.
Mr. Austin Harris,
Aye.
Honorable Arden McLean,
Please don't mix me up with
Abstain.
Mr. Avasaku,
Abstain.
Mr. Kenneth Bryan,
Abstain.
Mr. Anthony Eden, Mr. Christopher Saunders,
Abstain.
Mr. Ezra Miller,
Results of the division. 9 ayes. Abstention. 4. Absentees. 5. The motion has carried. One, two, three, 4. 1, 2, 3, 4, 5. I think the chair was right. Honorable Attorney, Honorable Premier.
Thank you, Mr. Speaker. Mr. Speaker, I move the adjournment of this honorable House until 10 a.m. tomorrow morning.
Question is that this Honorable Legislative Assembly do now adjourn until 10 a.m. tomorrow morning, Thursday the 6th. All in favor?
Aye.
Those against? The ayes have it. The Honorable Assembly stands adjourned until 10 a.m.